I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.
Hang on one second, I gotta recall it. Brian Palmer versus Sonia Stoneburner.
Ellis Friedman for the plaintiff.
Your name?
Sonia Stoneburner.
All right. I have before me a consent order for conditional dismissal. Is that what we're doing today?
Yes, Your Honor.
I thought everything was
Pardon?
fine. I didn't even know I had court until yesterday at 4:30 when somebody called.
Okay, you signed this conditional order of dismissal?
Yes.
All right. Did you have any questions regarding it?
No, sir.
All right. And you understand everything that's contained therein?
Yeah. Yes, I think. I haven't been living there at all. I moved out.
Pardon?
I've been moved out. I thought everything, when I signed the paper, he gave me the $1,500 out of the home.
Okay, so all of the conditions in here, you're moving out as well as the $1,500. That's already happened?
Yes, sir. Everything happened. And then I paid the defendant because I couldn't move out the time frame. So I had a lot of people there with me, including Attorney Dave, and we were moving things out, and he had me pay him $50 because I told him I may not be out by that specific date. He agreed right there, and he gave me into the original order of May 5th, and I've been out way before that.
Since that
Yeah.
time.
Yes,
Okay,
sir.
so I will
One.
then sign off on this conditional order of dismissal. It seems everything's done.
Yes, sir.
I will, and I have to advise you have 3 business days to think about this. If you think that there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I grant it, but you have that time to file it.
Yes, sir.
Okay?
Yes, sir.
All right. Thank you. You have a
so
great day.
much. You too.
Thank you, Your Honor.
Thank you, Mr. Friedman. Jeff Lewis versus Jennifer Loudon.
Your Honor, I don't think Jennifer Loan has arrived or plans on coming, for that matter.
What are we on now?
Subpoena was served.
What is this for? It's set for creditors exam.
This is debtor's exam, yes.
Oh, that's Miss Lewis. Okay. All right. And she's not appeared. I thought I had issued a default on this. Okay. She's not here. All right. So what I typically do in these cases is that then I will issue an order to show cause. From that order to show cause, then I would issue a bench warrant if she doesn't appear.
Okay, sounds good, Your Honor. I have a question. Can I approach the bench?
Yes, you can. I need a date for an issue to show cause. Maybe it's on the record. We'll set it for June 2025, 9 a.m. Court calls the case of Cross Street Properties versus Garrett Gate.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Derek Davis or Luke Hanna?
Your Honor, we actually resolved the case as to defendant Hannah and dismissed that party only
Yes.
from the case.
Did you see that?
So today we're seeking to proceed as to defendant Davis. I filed a motion for entry of default judgment as to that defendant. Notice of the request for entry of default judgment was served at least 7 days before the requested entry today in accordance with MCR 2.603 B1B. But just so the court is aware, the motion was filed 8 days before today,
Got it.
so that it's clear. But he has not appeared. This case started as a summary proceedings for possession and money. Then defendant subsequently moved out. We amended the complaint to add money damages. There was extensive damage to the property. And here we are.
And you're requesting a judgment in the amount of $8,000.
No, Your Honor, actually, the amount has increased. So the property has not been re-rented. It has been listed, but it has not been re-rented right now. The total amount of damages is $16,111.42. There's court costs of $397.10. The statutory $75 attorney fee for a total of $16,583.52. And that is after application of the security deposit.
That's after, yeah.
Yes.
Okay. All right. Derek Davis? Hearing no response based upon the motion that has been filed, as well as the indication from council, court will enter a judgment as requested by default.
Thank you, Your Honor. I will submit the judgment electronically.
All right, very good.
Thank you.
That just came in.
Yeah, apparently there's another bankruptcy in this matter. It's up for motion.
This is the one where she removed. Yeah. BMC Rio versus Nettie Whitlow.
Good morning, Your Honor. Ian Redmond, P70599 on behalf of the plaintiff.
And greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556.
Okay, good morning.
Your Honor,
Yes.
a new bankruptcy was filed yesterday afternoon, so we are not looking forward to doing anything today other than informing you of that bankruptcy.
All right. So what I will do then
Yes.
is I will administratively close the case. And pay the man.
And then if and when this reopens, we will do the same thing that we did a couple weeks ago.
So great, you'll be back, huh? No, go ahead.
Well, no, Your Honor, I'm just, would court entertain my motion to withdraw from this case?
Yes, I mean, if you file an order with the court, I'll sign an order of withdrawal.
Okay.
I
It
have
has
no
nothing-
objection at
right.
all. I would say that since this is administratively closed, depending on what the engagement was, the engagement may be terminated as of right now.
Right, but I think what would happen, well, I don't know, because do we have?
I'll just submit
We have
an
counsel
order.
listed.
We do have Mr. Greenwood.
All right,
I'll submit an
so
order.
submit an order to
Okay.
that effect. All right, thank you.
All right, thanks.
R&J Group Holdings versus Stafffield.
Your Honor, plan's ready. Defendant just advised me she needed to use the restroom and walked out. Wait a minute. Up to the court.
Yeah, I'll wait.
Thank you.
Sycamore Meadow versus Autumn Meadow.
Good morning, Your Honor. Attorney Carrie Green. This is Good morning, Your Honor. Emily Rule, PA827, defendant.
All right.
But I did give counsel updated ledgers this morning.
I got them late yesterday, so I did hand for that and any of the research that we have that they requested.
All right.
So, Your Honor, Ms. Meadows was told by the Sycamore front desk that she should just hold on to her money orders until they got things straightened out. So now that we know that things are on their way to getting straightened out, she just needs to give her money orders for the past couple months, get a fresh ledger, get that ledger to emergency housing fund, and we should be able to get this all resolved.
Okay.
On the pathway to finish line, Judge.
Halfway to the finish line? Okay. As long as we keep running in that direction, we'll be good.
Judge agreed. And
Because-
I apologize to the court. Obviously it's not me, but I do apologize as I'm standing here representing them. And we all know I don't like being in.
No, I know, and it's a process, right?
Yeah, for sure.
So you guys need a date out.
I think at least 3 weeks. For
That's
everything.
fine. I'm good with that.
Will June 10th work?
Works for me. That was-
All right. So I'll adjourn this to June 10th, 2025 at 9 a.m.
Here.
Then Sycamore Meadows versus Derek Hall.
So, Emily Rule for defendant.
And Attorney Carrie Bannon on behalf of plaintiff, Your Honor.
Mr. Hall has moved out. We do, however, have counterclaims, and so we would like that to be transferred to the civil docket. We're also waiting for hopefully a resolution.
Well, that'd be transferred to what? The civil docket?
That was my understanding of what would happen.
I don't know how that's the thing. I guess we could bifurcate the possession if he's vacated.
Well, the civil docket would normally be handled by Judge Barr. This is not going anywhere. So if you want to call it the civil docket, call it the civil docket. I don't care. So you still have your counterclaims.
Yes, and our concern is just for protecting defendant's credit, getting that down to a number that he agrees to, and then he will pay.
You send me a number.
I did give, but yeah, I will.
Will you send?
I will send everything.
Okay, send me a number and I'll take it to my client. But hopefully we'll be able to resolve this.
June 10th, 2025, 9 a.m.
Thank you.
Seeing a trend.
Just for some.
Just for some, okay. Sycamore Meadows versus Vernon Jantz Jr.
Again, Carrie Bannon on behalf of plaintiff. I'm actually handling your court officer assigned conditional dismissal on this one. It's my understanding Mr. Jantz is going to vacate by June 10th. Both parties have signed that.
That's correct, Jeff.
That's correct. Since counsel is on this case is conditionally dismissed. I've signed that. It works. Sycamore Meadows versus Curly Fulton.
Emily Rule for defendant.
Carrie Bannon on behalf of plaintiff.
So for this one, we do have some concerns with the ledger. I did not know that plaintiff was going to have updated ledgers, and so I am not prepared to argue everything. I apologize to the court for that.
Judge, I'm okay with June 10th on this one, if that's okay with you.
So I just want to make sure where we are on it. You got the updated ledgers
Yes.
now, and you think there are some discrepancies.
Yes, I believe there's a 1420 overcharge.
1420, and you're saying 1,420, or are you saying $14.20?
1,400.
Okay.
Oh, because if it's 14,
Because if it was
I
1420, Alan would pay it. No.
would pay for Alan.
Okay.
Alan doesn't need you.
Oh, okay. All right.
I didn't know Alan provided rental assistance.
No,
Neither did Alan.
sometimes I just spend his money. It's just the way it works. Okay. So June 10th.
Please.
All right. I'll adjourn this at June 10th, 2025, 9 a.m. Thank you. All to the bank of Felicia. Sycamore Meadows versus Clarissa. Is that how I pronounce it? Nichols.
Emily Rule for defendant.
Carrie Bannon on behalf of plaintiff.
And for this one, now that we have a ledger, we just need some time to get into it.
Okay. June 10th, 2025, 9 a.m.
Thank you.
And then Sycamore Meadows versus Kala P. Kayla P.
Good morning, Your Honor. Jill Bauer on behalf of Ms. P, who is also present.
Ms. P.
All right, where are we on this?
As we have the motions, I believe, up today, I filed a motion for entry of judgment. I know that you've read them,
Yes.
and I know that counsel filed a response to the motion for entry of judgment. She also filed a motion to dismiss, as I filed a response as well. I know that you've read everything, unless you have any questions. The only thing that I would briefly say is that, two things as to the health hazard that they're like, well, Judge, I don't know how you want to do this. I guess I'll stop talking and leave that part to you. And,
No, go ahead.
Judge, you know, my motion for entry of judgment is no triable issue. Partly that is, the thing I wanted to add is the arguments that they're making in their response and their motion to dismiss are legal arguments. So as to the jury trial, I don't believe that any of this is a jury trial issue. I think this is an issue for you to decide, whether it's in our motions or whether it's at a trial. So I wanted to put that out there first, because I truly believe, going over everything that has been filed, that's where we're at. As to the argument as to the health hazard, they claim that the health hazard was improper and it should have been a different notice. I would argue that where HUD is silent, state law trumps, and that's what this is at this point. And then the only other thing I wanted to add is the health, you know, the 7-day was never cured. You know, they had a chance to cure, and that's why we're standing here, because it wasn't cured. And I think that's all I have to say at this point.
I just want to make sure, I thought we were gonna ask.
Oh, do you want to do that first? Oh, I didn't know.
We talked about asking if you wanted to speak with us in the back to.
And I'm
talk
still
about it
agreeable
more
to-
fully, but.
Sorry,
when
you said you wanted him to rule on the motions, I figured you wanted that first, but if you wanted to talk first, I'm good with either, Judge.
What would you prefer, Your Honor?
Poor Judge.
I haven't said a word.
You
All
called
right.
the case, Judge.
Yeah, I did. So why don't I do this? Let me pass it. I'll talk to the two of you. Back.
Okay, thank you.
Let me call this one up. Miss Bauer could have stopped you at any minute, but she just didn't. And then she goes,
You know,
but I thought, no, never.
Well, I wasn't sure if you were winding your way.
Winding? Wow.
Oh, is that
Jill, you know I go straight in.
That's right. That's
So I
right.
don't line up.
She's winding into that.
Sorry.
All right. Court recalls the case of R&J Group Holdings versus Saffield et al.
Plaintiff is ready, Your Honor.
Counter plaintiff is also ready.
All right. Where are we on this, folks?
Good morning, Your Honor.
Good morning.
God bless you, Your Honor.
I have, trying to figure out exactly where our posture is on this case, because I received 2 emergency ex parte motions. Have you have those, counsel? Pardon?
No, I received one some time ago for an adjournment that's long since come and gone.
No, these were filed yesterday.
I have no such, I haven't been served with anything. I had no idea those were even in existence.
Well, and I'm trying to figure out, why are they ex parte? Why is the request ex parte?
Permission to speak, Your Honor?
Yeah.
Okay, good morning. They are ex parte because the order that Your Honor signed for $5,000 a month bond escrow, we are trying to revise that to $250,000 refinancing proceeds of another property.
This case is this case currently before the circuit court?
is currently it's been appealed. Your Honor's
Yeah.
judgment has been appealed, and we filed a motion to dismiss the appeal. It's still pending, but that's all I can tell you about that, Judge.
So we'll get copies of these to you, but that's what I mean, I'm not clear I understand these motions, because the first motion is to have a lending institution, you want the bond changed from 5,000 a month, which was the escrow order,
Correct.
to customarily then become your bond on appeal. You want that changed to a $250,000 bond.
Correct. And may I speak the reason?
You can, but I'm not even clear that at this juncture, I would have the jurisdiction to do that. Because I think you would have to request that of the circuit court to change the bond. I've set the bond when the case was before me. It's appealed. That, in my understanding, that's the only thing I can do once the appeal is filed. I can set the bond on appeal.
Likewise,
After that, it's the circuit court. So I don't even know that I can address this. I would also note, counsel, and like I said, we'll get you a copy. There's also this motion to have the R&J Group Holdings pay $250,000
Escrow bond.
for an escrow bond. I don't even know what that, they were the prevailing party, so I'm not even sure how that works. But,
yeah, I can't comment on it. I haven't seen any.
I know, and that how these got on. I set this for a hearing on the escrow.
That's what I was under the impression was here today.
I didn't know anything about it. They are not on this document.
For the payment out of the escrow? Is that what I set it for? And I'm not gonna, well, the appeal is still pending, correct?
Correct.
The court set the hearing and I called the court.
Yeah,
Said that they wanted us to come.
Sure,
So
why did I do that?
When is the hearing?
I must have been under some determination that something had happened with the appeal, but you're telling me it did not.
no, the appeal is pending in the circuit court on this matter.
Okay, then I can't do anything with escrow, so,
May I ask you a question, Your Honor?
sure.
Okay, Mr. Momina's client has made several threats out loud, even in the hallways of this court,
So, ma'am,
to burn the house down. Does the court have authority to issue a PPO against him? I am protecting 4 underage children, my mother on the wheelchair. I don't want him to burn the house because we have a pending case. It's totally out of order.
Your Honor, that's preposterous.
No, it's not.
It's
You even
absolutely,
heard.
I didn't hear anything like that. I don't,
Yes,
I've heard,
a lot
I've
of
seen a
people
lot of
did.
things in this case I've never seen before, including ex parte motions seeking a $250,000 bond.
Yeah,
That's
it's a breach of
preposterous.
contract, sir. This is a breach of contract case and a jury demand.
everybody done? No, I can't deal with anything. I have no jurisdiction. The jurisdiction at this point of this case rests with the circuit court.
Yes,
So
thank
Are
you.
you denying the ex parte motion?
I am,
Or refer.
yes, I'm denying them because they are improperly filed before me. Because I can't do that. You'd have to file those with the
Yes,
circuit.
do that, Your Honor.
All right,
Thank
so,
you.
all right.
Thank you, Your Honor.
Thank you.
Appreciate it.
Here, this is, so that no, that goes with it, trust me. Then court will stand in recess and give me about 5 minutes and then council come back.
Your Honor, I just want to make it clear, Mr. Campbell and Ms. Rule would like to join us in the back. Is that okay?
Campbell, yes, her, no. No, I'm kidding. Maybe see. Who's on the,
They are both in Zoom.
they're both on Zoom. Court does call the case, the people versus Alicia Brinson.
That's a lot of people.
Good afternoon, Your Honor. Simon Khalil for the defendant, Alicia Brinson, who was present via Zoom and consents to the Zoom
Yeah,
proceeding.
she was the one that let us know that she needed me to get out here as soon as I could. Well, didn't quite put it that way because she had things to do. Miss Brinson, can you unmute and turn on your camera? Really? So she was so impatient waiting for me, and I can't get her on the camera. Thank
Judge,
you.
I'm right here.
State your name.
Alicia Stevens. How you doing today?
I'm okay. Counsel,
That's
go
good.
ahead with your petition.
Judge,
It's going fine. I'm just trying to get this little last thing off of my record so that I can carry on with my life.
Okay, so maybe you didn't hear me. I said, counsel, go ahead with your petition. That'd be
Oh,
your
I'm sorry.
attorney.
Thank you,
Go
Judge.
ahead.
Thank you. This is my client, Ms. Brinson's application for an expungement for a 2009 conviction for operating while intoxicated. My client is now 42. She is self-employed. She works primarily in the cleaning business, and she also has her own food truck. She volunteers very consistently in the community, in the city of Detroit. She participates weekly in making sure that the homeless in her community are fed. She does have one minor child who's 10 years of age. The reason that she's asking that this court grant her application for an expungement is so that she can explore other employment opportunities. This conviction has impacted her ability to obtain employment. There is a letter from the Attorney General's office wherein no objections were stated, and we respectfully request that the court grant her application.
Any response from the people?
Your Honor, I wanted to be clear if the application is to the OWI account only or all three accounts.
The petition here I have is only to the OWI.
Then I have no opposition.
All right. Brenton, is there anything you want to say?
I just want to say that over time, of course, like I said, this was a situation where hello, can you see me? Okay. This was a situation where I was trying to do the right thing by parking and, realizing we all went out that night. My friend who was supposed to be the designated driver left with her boyfriend, so I had to drive. I realized I was too drunk to drive. I pulled over at Tim Hortons to go to sleep. And that is why I got the DUI when the police came up to my car. So I tried to do the right thing. That I was young-minded. A lot has changed since then. I'm now a home health care worker for the state of Michigan. I have a client that I have to be to at 2:30. So that's what I was. So I wasn't rushing you, but a lot of things have changed since then, Judge Simpson. I was before you before, and I was telling you that a lot of things have changed. It has gotten better. I do have my food truck in the driveway now. So things are good. Things are different. I've grown into my adult phase, and I just want to say respectfully that I apologize to the community for, the things that I was accused of doing.
Thank you.
No problem.
The court, having heard the allocution of the defendant, an opportunity having been given to the Attorney General and prosecuting official to contest this application, court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the conviction and is consistent with justice and the public welfare. The petition is hereby granted.
Thank you, Your Honor.
I've signed that. Thank you.
Thank you. Have a great day, Judge Simpson. Take care.
You do. You too.
The 14A District Court is now in session. All those having business before the court are here. The Honorable Judge Simpson presiding.
And good morning, everyone. Court does call the case of Dexter Shops LLC versus Whiskey and Rose Tanning Studio.
Good morning, Your Honor. David Waldo appearing on behalf of Dexter Shops LLC.
I don't have anyone signed in for the tenant.
You have nobody signed in for the tenant. I do have before me a stipulation and conditional dismissal.
That's correct.
And both sides are represented by counsel, correct?
That's correct, Your Honor.
All right, very good. Then what I will do is I will sign off on that. I will enter that. And you're all set?
You have a great weekend.
You do the same, sir.
Thank you, Judge.
Does call the case of DJM Land Company versus Mitchell Kish.
Good morning, Your Honor. For the record, Stuart Collis, P4953 on behalf of the plaintiff. I saw Mr. Kish's.
I think I do. Mr. Kish?
Good morning, Your Honor. Mitchell Kish here.
Good morning. All right. And what is plaintiff's claim in this case, including costs?
Your Honor, including costs, that would be $6,477.40.
All right. And sir, how are you intending on getting this paid if you believe that it's owed?
I've made a partial payment. They received a check. They should be in possession of for a partial payment for it, which should be leaving me a balance near $5,800. And I should have that paid within about 7 days next week on Friday.
Well, you're entitled to an adjournment on this, so I will adjourn this matter out. You think that you're going to have the balance paid by then?
Yes, yeah, I do.
All right, I will adjourn this to May 30th, 2025 at
1 p.m.
At 1 p.m. That is an in-person proceeding. It's not all taken care of.
Sounds good. Thank
you,
you.
Your Honor.
All right. Thank you. Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Egan for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391 on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. I'm trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that it would, that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the lease premises.
And
I'm sorry.
Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood. And then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well, let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law because you're supposed to give them 7 days to get in And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day, plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them
Why
today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untentable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple of problems with the order and the order that they proposed, Your Honor. Let me get specific, and because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language: dispose of any rubbish, trash, waste, and other water damage and/or flood damaged items contained in the leased premises. That's a problem because any maintenance person.
Then why don't you just ask that they can just that your client can look at it? I mean,
yeah, that's what I did in my motion.
Don't interrupt me. Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry.
If the issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property is being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay, that's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water damage.
Why don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right, here's what we're going to do. I'm adjourning this to next week. Between now and next week, I'm going to order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order. as drafted.
I'm not gonna enter that order. I'm gonna enter the order directing the parties to get with the county, to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow, or preserve escrow from today's date. Also, the case was filed under 657-14, 1C, 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that. And I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person
didn't mean I was supposed to be here. I wasn't able to be here.
Thank you. Glencoe Hills versus Justin Jefferson.
Jillian Engen for plaintiff.
Justin Jefferson. There is no response. And I also should say, is it Unganchuku Nasiki? Nasiki? No response. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,494.56. Court costs are $212 for a total of $3,706.56. Plaintiff is requesting a default judgment for possession only with a writ issue after 10 days. Do I have this after June 2nd?
Judgment to the plaintiff that is by default for possession, redemption amount, any amount requested, writ issue in 10 days. Court calls case Glencoe Hills versus Devonta Jackson and is it like China?
It's LaChina. You can call me China.
Say it again for me.
It's LaChina. You can call me China.
Okay, it's LaChina. Okay, I'm sorry. I didn't know where to break apart the syllables. LaChina Williams.
You got close enough.
Okay. All right. What is the claim in this case?
Your Honor, I have a balance including court costs of $1,818.50.
And LaChina, when are you going to get that? How are you going to get that?
I can get that paid by the 1st.
By the 1st?
Yes.
Okay, so here's our problem. I can adjourn it out a week, but the 1st, June rent is going to click in.
Oh, is the 30th okay?
Can you pay it on the 30th?
Yes.
Okay. Here's what we'll do. I'll adjourn this out to May 30th, 2025 at 3 p.m. That's an in-person hearing. So can you get that paid? Can you get that balance paid, say, before noon that day?
Yes.
Okay, fantastic. Okay, so if you get it paid before noon, then what likely will happen is that plaintiff will dismiss the case. But you may want to check with them, make sure you got everything paid.
Okay.
Okay?
All right. Thank you.
Thank you. You have a great weekend.
You too. Bye-bye.
Court calls the case of Glencoe Hills versus Daniel Worth.
Jillian Engen, plaintiff.
Hello.
Hello, Mr. Worth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Worth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at 0 by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing, I don't know if we're willing to do, I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right, so here's what I'll do, Mr. Worth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay $1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do June 2nd for the first payment?
I cannot.
Okay.
Because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd without 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay.
at 3 p.m.
Okay. Thank you.
Thank you. Glencoe Hills versus Daniel Reynolds.
Jillian Hagan for plaintiff.
Here. Mr. Reynolds?
Yes.
Okay, there you are. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance, including court costs of $2,068.70.
All right, Mr. Reynolds, how are you intending on getting that paid?
So approximately $750 I could pay by Wednesday of next week, and most of that today. And then that will leave me with my normal rent for the month of May, which I can make another partial payment on May 30th, but it wouldn't be the full amount of May on May 30th. I need approximately a week to 2 weeks to catch that up. And then I know I'll be due for June.
Hold on a second. You're going to pay $750 by the 28th. That's next Wednesday.
Yes, and that'll just leave me with May.
Okay, and then on the 30th, how much did you say you're going to pay?
I'll be able to pay roughly $600.
Okay, and then $600 on the 30th. I'd like that paid to the landlord before noon.
Sure
Okay.
thing. Yes.
And then I'll adjourn this out to May 30th, 2025, 3 p.m. That's in person. So then we can see where we can go from there. Okay.
Your Honor, would it be possible for an alternate viewing? I will be in Chicago on next Friday.
Okay, that's the time that I've set it in person. You can submit a form to the court requesting a Zoom hearing, and then we'll consider that.
Okay, and what is the best way to submit that? Do I go to the court, or is there an electronic version I could use?
I can put my email in the chat.
You can, my coordinator will put her email in the chat, and so you can make that request directly there. Okay.
All right. Thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Hagan for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes.
You got it. Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't.
Okay.
No.
Okay.
You would not have.
That would
So
be
you paid
different.
$2,400 last night?
Yes.
Okay. So I'm going to indicate that was the 22nd. You paid that.
Yeah.
And
yeah.
then, so that
yeah.
leaves you about 1,000 and some change. So when were you going to get the balance paid?
I can pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD. If you can't get it paid by noon on the 30th, is what you're telling me.
I can try. I don't want to make that promise because my money hit like different times. If that makes sense, I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay. All right. So here's what I'll do.
Okay.
I'll let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 p.m. That's an in-person hearing. And then we'll try to figure out how we're going to work it out if it's not paid by then.
Okay. Can I get that? May I get that balance again she has so I can minus the $2,400 from it so I'll know what I owe, if that's okay?
Yep. Yes. And I have $3,473.47. You can also contact Melissa.
Okay.
She'll give you
Okay. Yeah. And I'll definitely try to have that paid before 3 o'clock on the 30th. Thank you, Your Honor.
All right. All right. Thank you. Gulfside Lakes versus Lukia Williams and Karan Williams.
Jillian Hagan for plaintiff.
Hello, Your Honor.
Hello. All right. And Ms. Williams, do you have a camera?
Yes. Hold on.
All right. I'll need you to turn on your camera. And what is plaintiff's claim in this case?
I have a balance including court costs of $3,593.26.
All right. Ms. Williams, how are you intending on getting that paid?
So I can have about 593 next week,
but I am also in the process of working with Hawk.
Okay, so you're working with Hawk?
Yes, I had an
Do you have
appointment with her
do you have an
yesterday.
appointment with them yet?
Yes, I had one yesterday at around 1
Oh, you
p.m.
did? Okay. They haven't indicated anything then to you?
No, what was her name? I think Alicia. She said she's
Okay.
working on it.
Okay, so here's what I'll do. I'll adjourn your case out May 30th, 2025, 3 p.m. That's an in-person hearing, and hopefully we can have some news from Hawk. Try to figure it out. I suggest that you make the payment that you're going to make so that if there's funding there, you'll be below the limit that can get paid, okay?
Yes.
All right. Okay.
Thank you, Your Honor.
Thank you.
Pardon me, Judge. Could you ask
Yes.
your administrator to clarify the email address that she put in there? I've sent a question. It's a little confusing. Thank you.
Who's
I've already answered his question.
I think she answered your question, sir.
Thank you.
Gulfside Lakes versus Alicia Sarr.
Jillian Ingham for
She's here. Sarr?
Hello.
Hello, there you are.
Hi.
Okay. Hello. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $219.14.
$219.14.
Yes, sir.
Okay. All right, Ms. Sarr.
Yes.
When do you think you can get that paid?
So I made a payment arrangement to pay the rest of it tomorrow with the landlord.
Okay. So you're going to have everything paid. If I adjourn it out a week, everything should be paid.
Yep.
Okay. Then let me do that. I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's in person. But if everything's paid, it's likely they'll dismiss the case and then you don't need to appear.
Okay. Thank you.
Okay. All right.
Yep.
Take care. Have a good weekend.
Thank you too.
Court calls case of Gulfside Lakes versus Erica Hall.
Jillian Ingham for plaintiff.
She's there she is. Hello.
Hello.
And I got it right. So, and you know what? You didn't even say, good job, Judge. You didn't say anything. I got it right. I'm just saying that because I'm proud of me. So, all right.
The win.
All right. How much is owing?
I have a balance including court costs of $2,749.29.
You said 2749?
Yes, sir.
All right. Ms. Hall, how are you intending on getting that paid?
I can have everything paid by the 13th of June, but I know that's pushing it. I can make a payment of $600 by next Friday, and I'm taking out a personal loan, but it takes a few days for that to go through.
To get through.
Yeah.
Okay, so let's do this. Pay the 600 by next week. I'll just put by the 30th. You can pay that early in the day. And then I'll adjourn it out to May 30th, 2025 at 3 p.m. That'll be in person. And you might want to contact the attorney's office, see if they, since you know that you won't have it paid before the 13th of June, to try to work something out regarding a COD or something to get that in June encompassed. Got it?
Okay.
Okay. All right. We'll see you next week. Take care.
All right. Thank you.
Court does call the case of Gulfside Lakes versus Emmett Redwine.
Jillian Ingham for plaintiff.
Hello. Hello, Mr. Redwine. All right. I'm doing okay. All right. How much is owing?
I have a balance including court costs of $3,009.28.
All right, Mr. Redwine, how are you intending on getting that paid?
I'm gonna pay something Friday. I'm gonna pay something Friday. Then I'm gonna pay another $1,600. 2 weeks after that, then.
Okay, so how much can you pay by next Friday?
I'm gonna pay $750 Friday. It's Friday.
Okay, so $750 by the 30th. It looks like something's going to have to be worked out regarding a payment plan or something, if it can be. So then I'll adjourn this out May 30th, 2025 at 3 p.m. That will be in person, and then we can see if we can get something worked out. Okay, Mr. Redwine?
Okay. What time?
All right. That's at 3 p.m.
Okay, thank you.
Thank you.
Bye.
Court calls the case of Gulfside Lakes versus Michelle Goebel and Marlon Goebel.
Jillian Ingham for plaintiff.
Good morning. This is Michelle Goebel.
Okay, good morning. All right. How much is owing on this account?
I have a balance including court costs of $1,643.74.
All right. Ms. Goebel, how were you intending on getting that paid?
Yes, I get paid every other Wednesday. So I was planning on doing about $600 on the 28th and then the remaining balance on Wednesday, June 11th, both before noon.
On June 11th,
Yes,
but is that that's going to include your June rent or no?
I think so. Yes, yeah.
All right. So here's what I'm going to do. You said you can pay 600 by the 28th.
Yes, sir.
All right, get that paid. I'm going to adjourn the hearing to May 30th, 2025 at 3 p.m. That's an in-person hearing. And I suggest that you contact plaintiff's attorney's office, see if you can work out some type of either conditional order dismissal or something regarding this case. Okay?
Perfect. Thank you so much.
All right. Thank you. Have a great day.
Again, you too.
Gulf Side Lakes versus Mia Salvano.
Jillian Engen for plaintiff.
Mia Salvano? No response. You've been sworn. You may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent to retain possession is $2,784.07. Court costs are $172 for a total of $2,956.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Can you give me that amount again?
Yep, $2,956.07.
Got it. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Hamilton Crossing 2 versus Tanisha Ballard.
Jillian Engen for plaintiff.
Do not have this found.
Tanisha Ballard? I do not have her. You may proceed.
Thank you, Your Honor. We're actually looking to do a conditional order of dismissal with this one. I can place terms on the record, and it's going to be submitted to the court.
Okay.
Okay, so defendant may retain possession of the leased premises through the end of the lease term, provided that defendant complies with the following terms. As of May 9th, 2025, defendant has an outstanding arrearage of $2,178, includes $172 in court costs. Plaintiff shall pay the outstanding arrearage as follows. And I realize that some of these dates are before today's date. The payments have already been made in compliance with this. $300 on or before May 10th, 2025, $285 on or before the 10th of each month from June through November, and then $168 on or before December 10th, 2025. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through December 25th, 2025. And then commencing January 1st, 2026, defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So I see those certainly as more favorable terms than the entry of a judgment in this case. So I'll enter the COD when it's presented with those terms.
Thank you, Your Honor.
Hamilton Crossing 2 versus Joshua Myers. And is it Sheriff Myers?
Your Honor, Jillian Engen for plaintiff, forgive me, I switched my order. This is also conditional order of dismissal. I gave these terms I'm sorry, no, this is right. Okay, I'm sorry. Sorry, Your Honor. Okay, Jillian Engen for plaintiff. Your Honor, we have a conditional order of dismissal for this case as well. I can place terms on the record.
Go ahead.
Thank you. Okay, defendants may retain possession of the leased premises through the end of the lease term, provided that defendants comply with the following terms. As of May 9th, 2025, defendants have an outstanding arrearage of $5,189, which includes $214 court costs. Defendant shall pay the outstanding arrearage as follows: $415 on or before May 10th, 2025, $181 on or before May 25th, 2025, $415 on or before June 10th, 2025, $415 on or before August 10th, 2025, and $260 on or before September 10th, 2025, $415 on or before October 10th, 2025, and continuing with $415 per month on the or before the 10th of each month through April 10th, 2026, $28 on or before May 10th, 2026. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through May 25th, 2026, commencing June 1st, 2026. Defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So, and I do see those terms as being more favorable than an entry of a judgment by default. So the court will enter the conditional order of dismissal.
Yeah.
Court does call the case of Huron Vista Apartments versus Wilbur Burrell.
Jillian Engen for plaintiff.
You're on access. Yes.
Mr. Burrell?
Yes.
Okay, there you are. You're at our access point here.
Hello?
Hello?
Oh, can you hear me?
Yes, I can hear you. Can you hear me, Mr. Burrell?
Yes.
Okay. I don't have a camera on. I'm not sure why that is the case, but what is plaintiff's claim in this case?
Your Honor, I have a balance of $1,525. I also have a note from my client that Mr. Burrell is participating in the Huron Vista forgiveness plan. So I think that we should be putting together a conditional order of dismissal.
Okay. Is that your understanding, Mr. Burrell?
Yes, sir.
All right. So here's what I'm going to do, sir. I'm going to adjourn your case out to May 30th, next Friday, 2025 at 3 p.m. That's in person. So you'll actually come into the courtroom and hopefully we can have everything worked out.
Okay, yeah, because I talked to the landlord. He told me the terms and the conditions to make sure I pay this 3 months and then get help from my SER, from my DHS broker.
And I understand the program over there here on Vista. So they just have to work out the paperwork and we'll have to enter the paperwork next week. Okay.
Okay.
All right. We'll see you then.
Okay. What day you say? Next Friday at 3 o'clock?
At 3 o'clock. Yes, sir.
All right. Thank you.
Thank you. Court calls the case of Huron Vista versus Alicia Moore.
Jillian Ingen for plaintiff.
Alicia Moore.
I'm just.
Okay. Hello.
Hello, Judge.
What's your name?
Alicia Moore.
Okay. Yes. Okay. All right. She's on the phone. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $3,522. I also have a note that Ms. Moore is participating in the Huron Vista forgiveness plan as well.
Okay, so Ms. Moore, what I'll need you to do is I'll need you to come down to the court next week. Hopefully we'll have a conditional order dismissal to enter that regarding the program over there at Huron Vista, okay?
Okay.
So I'm going to set it for May 30th, 2025 at 3 p.m.
Okay.
All right, we'll see you then. Thank you.
Thank you.
Huron Vista versus Jacqueline Taylor and is it Tania Taylor?
Good morning, Judge.
Good morning, Judge.
Good morning. And who I'm sorry.
Jacqueline Taylor. This is Jacqueline Taylor.
Okay, gotcha. Okay. All right. What is the claim in this case?
I have a balance including court costs of $2,194.03, and I don't have any notes regarding the forgiveness plan.
All right. Okay, Ms. Taylor, how are you intending on getting that paid?
I'm going to pay something next week. I had got an email about the forgiveness plan, but I didn't get the letter about it because I fell on the property. That's how I got behind in my rental payments, which I told them. I fell and then I had to take off of work because I hurt my wrist and my knee.
Okay. So, I don't know. Is she eligible for the program or you don't know, counsel?
I'm sorry, I'm not sure.
Not sure?
I'm not sure. That would have to, but I will.
All right. So, Ms. Taylor, have you reached out to the landlord regarding the forgiveness program or not?
I can email today. I will email today when we're done.
Perfect.
Okay. Then here's what I'm going to do. How much did you say you can pay?
500 by the 30th.
Okay. So I'll indicate that you're going to pay 500. I'll put that by the 30th sometime. I'll adjourn this out to May 30th, 2025 at 3 p.m. That will be in person. Okay.
Okay. Okay.
And then hopefully you'll email them and hopefully we can work something out on that date. All right.
Okay. Thank you so much.
All right. Thank you. Have a good weekend.
You as well.
Huron Vista versus Rodney Taylor.
I have Jillian Ingen for plaintiff.
He's here. Oh, there he is. Mr. Taylor, I'll need a camera, sir. And how much is plaintiff's claim?
I have a balance of $2,223, and Mr. Taylor is participating in the forgiveness plan.
Okay, Mr. Taylor, is that correct?
That's correct. I'm trying to turn my camera on. I can't turn it on. I'm having some problems up here.
Okay, here's what I'm going to do. Since you're participating in that program, we'll need you here next week, May 30th, 2025, 3 p.m. in person. Let's get the paperwork together and get that all in. Okay, sir?
All right, no problem.
Okay, thank you. Oh, you got on just at the last minute. Now I know on the 30th who I'm looking for. Your camera's working. You get it. All right?
Yes, sir.
All right, you take care. You have a good weekend.
You too.
Huron Vista versus, is it Charkeisha Roberts?
Jillian Ingen for plaintiff.
Charkeisha Roberts, she's not here. You may proceed if you'd like.
Thank you, Your Honor. I am going to take a default judgment. I have rent to retain possession of $2,816. Court costs are $176 for a total of $2,992. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. And Your Honor, for the record, Ms. Roberts had indicated that she wished to participate in the forgiveness plan. If she does end up, we'll prepare a COD that sets aside the default judgment.
Got it. Okay. Judgment to the plaintiff that is by default for possession, redemption amount in the amount requested, which issue in 10 days. Here on Vista Apartments versus Moesha Harrison.
Jillian Engen for plaintiff.
Moesha Harrison, not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent routine possession is $2,230. Court costs are $176 for a total of, of $2,406. Plaintiff is requesting a default judgment with the writ to issue for possession only with the writ to issue after 10 days. And also, if Ms. Harrison does agree to, she has indicated she wants to participate in the forgiveness plan. I'm sorry, my words are, I haven't had enough coffee today.
We'll set aside the default and enter that.
Yes, sir. Thank you.
Okay. Judgment to the plaintiff by default for possession, redemption about any amount requested, writ issue in 10 days. Here on Vista versus Chinar McGraw.
Jillian Engen for plaintiff.
McGraw, no response.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $49. Court costs are $176 for a total of $225. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff that's by default for possession, redemption amount any amount requested with a writ issued in 10 days, no writ without a hearing.
Thank you.
Court does call the case of Here on Vista versus Danielle Davis.
Jillian Engen for plaintiff.
Danielle Davis, they are not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,346. Court cost of $176 for a total of $3,522. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. However, if Ms. Davis does agree to enter into the forgiveness program and enters a COD, we will set aside the default in the COD.
All right. Judgment to the plaintiff that is by default. Possession, redemption amount is in the amount requested with a writ issue in 10 days. Evergreen Apartments versus Abraham Hack.
Hello, Your Honor.
Okay. All right, Mr. Hack, he's got his camera on.
Hello.
Hello.
All right. How much is owing on this guy?
I have a balance including court costs of $2,823.88. Your Honor, I also do want to note that Mr. Hack has provided a notice to vacate for the end of his lease on June 15th. And so if this case continues till June 15th, we will likely, and Mr. Hack moves out, we will likely end up dismissing.
Is that correct? Is all of that correct, sir?
Yeah, it looks like it's all correct from what I got on the paper.
Okay. Are you going to be able to make a payment before the 30th?
Yes. I should be getting my last paycheck from my previous job before that.
Do you know how much you can pay by the 30th?
Unfortunately I'm locked out of my Alti-Pro that tells me how much I'm going to be paid on the 30th. So I don't have an actual estimation of how much, but I'm trying to save up as much as I can to pay as much as I can, Your Honor.
Okay. All right. I'll adjourn this out May 30th, 2025, 3 p.m. That's in person. All right.
Okay. Just because I'm a little bit slower, can I just the total cost of what I owe just one more time in person at 3 p.m.
The total amount that they claim is owed is $2,823.80. Was that 88 cents?
88. Yes, Your Honor.
And then I was supposed to show up 3 p.m. At what was the address? Is it on the paper that I received at all?
Yes, the court address is 4133 Washington.
4133 Washington.
Right up by the sheriff's department. Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you, sir.
Am I good?
Evergreen Apartments versus Idris Williams. You're all set. Sure.
Jillian Engen for plaintiff.
And Mohammed Al-Duwasi.
How's it going?
All right. Who is this?
Idris.
William, how you doing, Idris?
How you doing?
I'm doing well. All right. How much is owing on this case?
I have a balance including court costs of $1,989.60.
All right. And Sarah, how is that going to get paid?
Oh, both myself and my brother, we both recently started brand new jobs. I graduated last month. You wish me happy birthday and the graduation present. I got that all paid up and everything. That previous one paid up. It's just catching up on this 1 month that we're behind now. So I'm literally outside of my job the job. I'm signing paperwork for my new job. Like I was supposed to be at 9 o'clock. I already went inside and told them I'm gonna be a little late. And my brother, he started a new job last week, tiling floors. So he's getting paid a decent amount now, and I'll be getting paid $23 an hour. So it's literally just getting that handled out. We're both still working our other job as well at night at the restaurant in Ann Arbor. So literally, it's just trying to get caught up with that 1 month that we are behind, and it was like 1 month and like 200. Yeah.
All right, let's do this. Let's do this before you lose that job that you haven't started yet. I'm going to adjourn it. I'm going to adjourn it out to May 30th, 2025 at 3 p.m. All right, that's an in-person hearing. I'm going to suggest that you contact on your paperwork. You'll see the attorney's office number. Call them and see if you can work something out regarding this back balance. Okay,
sounds good. Yeah, no, like next month, everything should be cleared up. It's just because like I said, I graduated. You know the whole situation, so literally it's just trying to play catch up. So I really appreciate it.
Like I said, well, congratulations on the graduation. Get in there, get that job. Yeah, and let's see if we can get it all worked out by next week. All right,
yeah, I'm using this degree to work. All right, have a nice day.
All right, you take care.
Yeah, you too.
Evergreen Apartments versus Walter Herrera and Daniel Alvarado and Randall Romero.
Jillian Ingan.
Any of those individuals present? Herrera, Alvarado, Romero. Nobody's present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent retained possession is $3,611.86. Court costs are $256 for a total of $3,867.86. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Evergreen Apartments versus Daryl Simpson, no relation.
Jillian Ingan for plaintiff.
Daryl Simpson, not here. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent retained possession is $1,592.04. Court costs are $172 for a total of $1,764.04. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Evergreen Apartments versus Denasia Hamilton.
Jillian Ingram for plaintiff.
Hamilton,
morning,
oh, there
Your
she is. Good morning. All right, how much is plaintiff claiming is owed?
I have a balance including court costs of $2,084.66.
All right, Ms. Hamilton, how are you intending on getting that paid?
I contacted my caseworker from DHS. I'm just waiting to hear back. And then I also have some other organizations that I'm waiting to hear back so they can put together and see if they're gonna help pay.
All right. So have you filed for an SER through DHHS?
Yes.
Okay. So what I would need you to do, I'm going to adjourn this case out May 30th, 2025 at 3 p.m. That's in person. There's a form that came with your packet notifying you of this hearing. That's called a rental assistance form. You'll have to file that with the court by next Wednesday and put your tracking number on that form. Okay.
Okay.
Okay. If you can't find that paperwork, you can use the QR code on the screen, or you can call our clerk's office and they'll be more than happy to give you a copy.
Okay.
Your Honor.
All right. Yes.
If I may, I have a note from my client that Ms. Hamilton's SER application was denied. I just wondered if she's filed a new one or if she's going to reapply.
Yeah, I filed a new one as of last night.
Okay.
Got it. Okay. All right. So get that information down to the court, and then we'll see you next week at 3.
Okay. Thank you.
Thank you. Court does call the case of Evergreen Apartments versus Kayla Smith.
Jillian Ingan for plaintiff.
Smith? Hello? I think she unmuted. Kayla Smith? Can't hear you, nor can I see you. You'll need to turn on your camera. Not getting a response. Okay. Oh, now there she is. All right, Ms. Smith, can you hear me? Okay. I can't hear you. I can see you now, but I can't hear you. All right, Ms. Smith, do this for me. Can you hear me? Nod your head if you can hear me. All right. Sign off and then sign back in. Okay. And let's see if that'll correct the problem. I'll pass your case. Evergreen Apartments versus John Hudson.
Jillian Ingan for plaintiff.
Hello?
Hello, Mr. Hudson. How are you, sir?
I'm doing pretty good. Yourself?
I'm okay, I think. All right. Okay. How much is owing on Mr. Hudson's account?
I have a balance including court costs of $1,291.
All right. And Mr. Hudson, how are you intending on getting that paid?
I'm intending on getting that paid by next Friday.
Okay, so you're gonna get the balance paid by the 30th. Can you get that paid before noon on the 30th?
Yes, sir.
All right, so I'm gonna put that here that you're gonna pay the balance. If you get it paid and make sure everything is paid on your account, it's likely they'll dismiss your case. Okay?
Okay, cool.
So, but I'm gonna adjourn it to May 30th, 2025, 3 p.m. If it's not paid, you need to be here in person, okay?
Okay, sounds nice.
All right, take care. Have a good weekend.
All right, you too. Thank you.
Evergreen Apartments versus Nelsa. Is it Nieves Montez?
Yes.
Montanez. I'm sorry.
Jillian Engen for plaintiff.
Hello. Oh, there she is. Okay. All right. And how much is owing on this?
I have a balance including court costs of $3,705.12.
All right. And how are you intending on getting this paid?
I told him I was going to pay some on the first, and then SOS was going to help me with the rest of it. But first, I have to pay a certain amount on the first.
I'm sorry. Say that again for me.
I told her I was going to pay a certain amount on the first, and then SOS will help me with the rest because I had to pay a certain balance for SOS to help me with the rest of it.
All right. So you got to get down below the 3,000.
Yes.
Is that what you're looking? Okay, but if that happens on the first, your new rent kicks in. Your June rent kicks in.
Yeah, she told me that yesterday.
Okay. So are you going to try to get everything paid by then? Or
yes.
All right, let's do this. I'm going to adjourn it out 1 week, the 30th, 2025 at 3 p.m. That's in person. And whatever you can get paid before that date, let's try to get that paid and also try to figure out exactly where Hawk may be or SOS would be with you on this case.
Did you say
Okay.
the 30th?
I'm sorry?
Did you say the 30th?
Yes, ma'am.
I don't get paid until the first. That's why I told her the first.
No, I understand that,
Okay.
but we got to try to figure out, you get a 1 week adjournment, but we got to figure out how to do that. And on the first, your June rent clicks in.
All right.
And I have that amount for the record. It's going to be $5,000. The total will be $5,388.17. So we're looking at least $2,388.17 would need to be paid before if Hawk is paying $3,000.
Got it. Yeah. Okay. All right. Thank you, ma'am. We'll see you next week.
See you next week.
Evergreen Apartments versus Keith Johnson.
Jillian Engen for plaintiff.
Keith Johnson, no response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent retained possession is $3,176.29. Court costs are $172 for a total of $3,348.29. Your Honor, my client has indicated for Mr. Johnson that they would be willing to set aside the judgment if possession or payment is received by the second. And so I'm going to include under further orders that this judgment will be set aside if paid in full on or before June 2nd, or if defendant moves out and turns.
All right, very good. All right, thank you. Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issued 10 days. Court calls the case of Evergreen Apartments versus Evelyn Carter, Myron Moyer.
Jillian Engen for plaintiff.
Any of those folks? Okay, and when you say I'm here, who are you?
Evelyn Carter.
Thank you. All right, and how much is owing on her account?
Yeah, Honor, this is a case for termination of tenancy.
Yeah.
Tenants provided a notice to vacate that they were going to be vacating function on May 4th, and they have not yet vacated.
Okay, Ms. Carter, what's your position on this?
Okay, so they told me that my lease was over on May 3rd, no, May 4th. So I signed that. I'm thinking I have to move because I got a new voucher, new size voucher. I went to RPI. RPI had already paid May's rent and said my voucher doesn't expire until May 31st. So he told me to stay there until May 31st because I was moving already on June 2nd. I already packed up, already got the DTE scheduled to be disconnected, everything. That's all I knew. I didn't know what else to do about it because RPI said that they paid them and the voucher is expiring on May 31st. Your lease doesn't terminate until May 31st on our end. So I called Swap and they just told me to go to court and see what happens with that because I'm already moving, what to do.
Okay. So what day are you going to be out?
Okay, my voucher starts June 1st, but my move-in date to my new unit will be on the 3rd of June. So I already have everything scheduled to be turned off for the 6th of June, but if I can get until the 3rd, that'll be fine.
Okay, so here's what I'll do. I won't enter a judgment today, but I'll adjourn this out to May 30th, 2025, 3 p.m. in person, and then we can figure out a move-out date and everything else on that, okay?
Thank you.
Okay, thank you so much.
Thank you. Court recalls the case, Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
All right, I see you again, Miss Smith. Can you hear me?
I can hear you.
Okay, we can hear you. Now we did it. Okay. Okay. All right. What is it? What is plaintiff's claim in this case?
I have a balance including court costs of $2,902.30.
All right. And how are you going to get that paid?
I applied for SER and I'm just waiting on a decision for that.
Okay. So how many people are in your house?
2.
2?
Yes, me and my daughter.
Okay. So just so you know, that's only going to net you about $520. Okay. If they approve it. Okay. So then we have to figure something else out. So what I'll do is I will adjourn this to May 30th, 2025, 3 p.m. That's in person. And there's a form that you'll need to file called a rental assistance form. You can either get the QR code off our screen, a copy of one came in your packet, or you can come to the court. I'll need to have that filed with the court with your tracking number, your DHS tracking number. You'll need to file that by Wednesday.
Okay.
Okay?
Okay, thank you.
Thank you.
Thank you for calling Language Line Solutions. My name is Carmen, ID number 204643, Spanish interpreter. May I please have your 4-digit access code?
Yes, our number is 1423.
1423. Oh, one moment. 1423. Thank you. I am ready for your instructions.
Can you please raise your right hand to be sworn?
Yes, one moment. There you go. I'm ready.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court? So help you God.
I swear to the best of my ability. So help me God.
Thank you. And good morning, Madam Interpreter.
Good morning, Your Honor.
All right. The court does call the case of Evergreen Apartments versus Lunette Yoder and Jose Contreras.
El tribunal va a ver el caso entre Evergreen Apartments y Lunette Yoder y Jose Contreras.
Yes, that's right.
Jillian Engen for plaintiff.
Habla Ghislaine para el demandado.
Okay. And Ms. Yoder, can you state your name, please?
Señora Yoder, por favor, diga su nombre.
Hola, soy Lunette Yoder.
Hello, my name is Lunette Yoder.
And how much does plaintiff claim is owing in this case?
¿Cuánto se alega que el demandante debe en este caso?
I have a total of $2,775.48.
Aquí dice que son $2,775.48.
Ms. Yoder, how are you intending on getting this paid?
Señora Yoder, ¿cómo usted tiene pensado pagar eso?
He estado tratando de comunicarme con diferentes lugares para que me ayuden a pagarlo, porque ya que soy madre soltera, pues mis recursos ahorita están muy bajas y fue como una situación que traté de ayudar a otra persona. Entonces, pues yo tengo mi otro apartamento y pues yo les había dicho que quisieran pagos, pero no me dejaron la opción. Entonces estoy tratando de pedir ayuda para ayudarme a pagarlo, ya que soy madre soltera y me cuesta mucho recoger esa cantidad de dinero.
Well, I've been trying to see if I can get the money from different places. I am a single mother, and when it comes to my resources, I have little resources. A situation came up where I had to help someone, and I have another apartment, so I had asked if I could make payments, get a payment plan, but they did not allow that. So I'm waiting to see if I can get help since I am a single mother and I just don't have all that money to pay this.
Have you tried to get help through our HOT program?
Your Honor, for the purpose of accuracy, HOP?
No, it's HAWC.
Thank you, Your Honor. ¿Ha tratado usted conseguir asistencia a través del programa HAWK?
No, nunca lo había escuchado. De hecho, yo no estoy muy al tanto de tantos programas aquí, ya que tengo muy poquito tiempo y no.
No, I never heard of that. As a matter of fact, I just don't, I'm not aware of all the programs that are available here because I haven't been here that long.
Okay. Here's what I'm going to do. I'm going to put you into a breakout room with the interpreter and Amy from the county, our court liaison officer, and she can describe certain programs that might be available to you.
Ok, lo que voy a hacer es voy a sacar un tiempo ahora para que usted, la intérprete y Amy del tribunal se comunique con usted ahora, aparte de la sala judicial, para que ella le pueda dejar a usted saber todos los programas de asistencia que hay disponible.
Ok, excelente, me parece muy genial y muchísimas gracias.
Excellent, that's genius. Thank you so much for that.
And I will adjourn your case to May 30th, 2025 at 3 p.m. And that's an in-person hearing, so you'll have to come down to the court.
Y voy a aplazar su caso hasta el 30 de mayo de 2025 a las 3 de la tarde. Y para esta audiencia tiene que venir en persona al tribunal.
Ok, ¿y esa información me lo mandan por correo electrónico o directamente a ese apartamento? Ya que no vivo ahí, pues no tengo cómo sacar las cosas que me llegan ahí.
So that information, is it going to be provided electronically to me or mailed to the apartments? Because I no longer live there and don't have access to get mail there.
Got it. So you're no longer living at the address, ma'am?
Ya veo, así que ya usted no vive en esa dirección.
No, de hecho, es que la situación fue así, que una señora que estuvo en calle con sus hijos, yo le di el apartamento a ella para que ellos tuvieran tiempo mientras que yo iba para mi país a ver a mis hijos, porque como yo tengo mis hijos en una situación de migración, yo me fui por unos cuantos meses y cuando regresé, pues todo había un caos aquí con ese apartamento, pero ya yo había movido mis cosas a otro apartamento que ya, de hecho, ya yo tenía que desocupar ahora en este mes que viene, entonces yo tengo mis cosas en otro apartamento y ya que regresé, pues ya yo estoy en este otro apartamento, entonces no estoy ahí.
No, the situation is I try to help this lady that was homeless with her children. So I let her stay in that apartment while I went back to my country because my children are currently going through an immigration process. So I went for a few months back to my country and I left the lady in that apartment. When I came back, I encountered all this chaos going on. But I was in another apartment. And as a matter of fact, I have to move to I'll be moving to another apartment this month coming up now. So I no longer live there. I live somewhere else now.
Okay.
Your Honor, can I ask, does Jose Contreras live in the apartment as currently?
Your Honor, may I get a clarification of which apartment?
Yes.
Thank you. Ms. Gilliam, may you clarify the question, please? Mm-hmm.
Let me get the address. Ms. Yoder, does Jose Contreras live at the apartment on Woodland Hills?
Señora Yoder, el señor José Contreras vive actualmente en el apartamento en Woodland Hills.
No, él nunca vivió ahí, simplemente a mí me pidieron que alguien estuviera como debajo de mí, lo que sea como para que yo pudiera sacar el apartamento, pero él no tiene que ver nada en esto, digamos, nunca vivió ahí, solamente me hizo el favor de ayudarme.
No, he's never lived there. He just helped me put his name so that I could get into the apartment, but he never lived there. He just helped me to put his name below my name.
Your Honor, if Ms. Yoder would surrender possession and we could place something on the record, I could dismiss as to her and then take a judgment as to Mr. Contreras and as to all other occupants.
Ms. Contreras, or I'm sorry, Ms. Yoder, you have surrendered possession of the unit on Woodland Hills Drive?
Señora Yoder, ¿ya usted entregó posesión de ese apartamento en Woodland Hills Drive?
Hace como un mes yo fui, hablé con ellos, les expliqué la situación y yo fui a entregar las llaves, pero ellos no aceptaron las llaves, me dijo que no lo iban a aceptarlo hasta el 1 de junio.
I went there a month ago and I explained to them the situation. I went to turn in the keys, but they said they could not accept it until the 1st of June.
All right. You will need to go over and turn in your keys because it sounds like you are not going to be living in the premises.
Es necesario usted regresar de nuevo allá para entregarle la llave porque me parece que usted no piensa vivir en esa localización.
Sí, correcto. De hecho, yo como le expliqué, ya yo traté de hacerlo porque de hecho ya el leasing de ese apartamento ya está para este mes que entra o si no el próximo mes que entra. No estoy muy seguro, tuve que fijarme en la fecha exacta, pero yo les dije a ellos que no iba a vivir más y de hecho yo quería entregarlo, pero ellos no me lo quieren aceptarlo. Por eso pasó, digamos, por eso estoy en espera.
Yes, I already tried to explain that to them, and I believe the lease on that apartment, I believe it ends either next month or the following month. I have to check the date, but I told them the situation that I was not living there, and I wanted to turn it in, but they did not accept it.
All right. Ms. Yoder, you're giving up your right to reside in that premises. Is that correct?
Señora Yoder, usted está renunciando a su derecho de vivir en esa localización, ¿es cierto?
Correcto, así es.
Yes, correct. That's true.
Okay. Then I will indicate that the defendant one, Ms. Yoder, has surrendered possession. I will grant a default judgment to plaintiff as to defendant two, Mr. Contreras, for possession with a writ to issue in 10 days.
Thank you, Your Honor.
Your Honor, would you repeat that again?
Okay. Defendant one, having surrendered possession, that being Ms. Yoder,
La demandada número 1, la señora Yoder, ha entregado posesión.
I will grant a default judgment in favor of the plaintiff against Mr. Contreras for possession of the unit.
Voy a otorgarle un fallo por incumplimiento a la demandada y por el demandado número 2 tener posesión del apartamento.
With a redemption amount of $2,775.48.
Allow me one moment while I reference a term, please.
Yeah, that's it.
Thank you. Con un importe de rescate por la cantidad de $2,775.48.
If that is not paid, an order of eviction will issue in 10 days.
Si no se paga eso, pues entonces se hará una orden de alojamiento dentro de 10 días.
Thank you, folks.
Gracias. This is the interpreter.
Yes,
is there anything else I can do for you?
No, ma'am. Thank you very much. Wonderful job. Do appreciate your help.
You're welcome, Your Honor. Thank you for using our services. You have a good day. Bye-bye.
You do the same. Bye-bye. I am not doing break overtime. All right, that ends that block.
Thank you, Your Honor.
Thank you.
You and your staff have a good weekend.
You do the same. Court stands in recess.
The 14th District Court is now back in session. The Honorable Judge Simpsons presiding.
And good morning. Northfield Estates versus Cheryl Cornett.
Good morning, Your Honor. Rachel Jordan, Alex Law on behalf of the plaintiff.
We have.
I'm here.
Cheryl Cornett.
Yes, Cheryl Cornett.
Okay. All right. What's next claim this case?
With cost, Your Honor, $1,512.12.
All right. And Ms. Cornett, how are you intending on getting that paid?
I'm not sure. I've had COVID for the last 3 weeks and I'm still not right. I was going to ask if you could give me at least 3 weeks. I have a doctor's note. My other half that lives here with me, he got COVID also. So neither one of us have worked in the last few weeks. So I'm just asking if I could at least get 3 weeks.
Well, you'll have to try to work something out with the plaintiff regarding that. What I will do is I will adjourn this proceeding to see what you can possibly work out. I'll adjourn it to May 30th, 2025 at 2 p.m. That's an in-person hearing, ma'am. So you need to contact either your landlord or plaintiff counsel's office to see what you can work out regarding payment.
So I have to come into, this is in Chelsea, or Ann Arbor Saline Road?
No, it's the court by the sheriff's department off of Washtenaw.
Oh, okay, okay, I'll have that, okay. All
Okay.
right, thank you. All right, thank you.
Northfield Estates versus Jason Armbruster. Jason Armbruster? No response. If you'd like to take a default, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. There's rent to retain of $3,006.99, cost of $217.80 for a total due of $3,224.79. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ issue 10 days. Northfield Estates versus Chad Gibbs. Chad Gibbs, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $179.32, cost of $217.80 for a total due of $397.12. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession, redemption amount in the amount requested with the writ issue in 10 days. I will indicate since it's under 200, no writ without a hearing. Court does call the case of Northfield Estates versus Tamara Coppens. No response. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,016.99, cost of $217.80 for a total due of $2,234.79. And we'd ask for a default possession only judgment with writ issue after 10 days.
Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested with a writ issue in 10 days. Northfield Estates versus Chris Woody. That matter is dismissed on plaintiff's motion without prejudice. Is that it for you?
Actually, Your Honor, my client just notified me. It looks like there were some additional payments on 2 accounts where I believe we can actually dismiss 2 of these defaults.
Say again.
Yep, the
Okay, go ahead.
chat matter, Your Honor, the 254C0671LT, this was the default, no writ without hearing.
Yes.
My client advised that they have paid in full, so we would like to not proceed with that judgment and instead submit a dismissal. And same with Jason Armbruster, 669 are the last 3 on that case. They are also paid in full, and so we would like to not proceed with the judgment in that case and instead dismiss.
Okay, and matters based upon that are dismissed without prejudice.
Perfect. Thank you, Your Honor.
Thank you. Take care.
Bye-bye.
Bye-bye. Bishop Pickering versus Andrew Rich.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
Okay, Mr. Rich. He's at the access point.
Yes, he is.
Can you unmute yourself, sir, or hit the space bar? Thank you.
Hello.
Hello, Mr. Rich.
How you doing?
Okay. How much is owing?
Your Honor, I'm
Yes.
here. They got me here for non-payment of rent, but I paid my rent.
Okay, hold on. Let me see what they're claiming. Mr.
Yeah, I got my
Frontier.
receipt in my pocket.
Hang on. Hold on. Mr. Fantera, how much is plaintiff claiming is owed?
His current balance is $956, and he is correct that he made a payment since we filed the case.
but he missed payment a couple months ago, so he's 1 month behind when he makes his payments.
That's not true.
All right, so Mr. Rich, here's what I'm gonna do. I'm gonna adjourn this to May 30th, 2025 at 12 p.m. noon. That's an in-person hearing. Why don't you bring all of your receipts to that hearing, and then you can go through them with the attorney along with the ledger and see what's been paid and what hasn't been, okay?
Right, but what I was trying to say, I get my check, my disability check, 25th and the 26th every month. I'm always early. I never ever not pay.
Okay, all right, Mr. Rich, I can't decide that right now. That's why I'm gonna put it out a week. You bring all of your receipts, they'll have a ledger, and you can go through all of that, but we can go through it and try to figure out if you owe anything or not, all right?
Right, because I got my receipt right here for this month, and I paid it, and the same day that I paid my
Mr.
rent.
Rich, I hear you. I need you to come down next week, bring all of your receipts again with you. There'll be a ledger here, and we can go through it and try to determine if you're missing a payment.
I'm not missing no payments, no way.
Okay, Mr. Rich, that's the best I can do. We'll see you next week. Noon.
What date?
May 30th.
May, we'll write that down, May 30th. What time, 12 o'clock?
12 noon.
12 noon?
Yes, sir.
Yeah, they got me tripping. They got me saying I'm
Okay.
always, my rent is always.
All right, thank you. We'll see you then.
Will I be coming in person?
Yes, sir.
I would like to come in person because I'm not good with these computers.
Okay, it's an in-person hearing. You'll come right down to the court, bring your receipts, they'll have a ledger. We'll go through it.
Okay.
Thank you. Bishop Pickering versus Holly Hollis.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is $1,539.
You said $79?
1539.
39. All right, Ms. Hollis, how are you intending on getting that paid?
I filed for SCR through M Bridges, and I've been paying on my rent every couple weeks because I had lost my job and I had, fell behind. And
Okay. So how many people are in your household?
Just by myself.
Okay. So the max that they're gonna pay on that is $410. Okay, for an SCR. But here's what I'll need you to do. I'm going to, first of all, adjourn your case to May 30th, 2025, 12 noon. That's going to be an in-person hearing. Okay? And you'll need to file in your paperwork, you would have seen a rental assistance form. You'll need to file that with the court by Wednesday. If you don't have it in your paperwork or can't find it, you can either use the QR code that's on our screen, or you can come down to the court and get the form.
Okay. Sounds good.
Okay?
Yes, sir.
All right. Thank you. We'll see you next week.
All right. Have a good day.
You too. Sandy McFiddish versus Stephanie Sims.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is $2,125.
Okay. Ms. Sims?
Here, Judge.
Hello. How are you intending on getting this paid?
Your Honor, can I interrupt, please?
Yes, go ahead.
So Ms. Sims and I spoke today or yesterday, and what we agreed for $500 before next Friday. Then when she comes to court next Friday, I'll give her a payment plan.
Okay.
And she understood that, and I think she agreed with that.
Is that correct, ma'am?
Yes, sir.
Okay. Well, you guys are making it easy for me. So you got to do that by the 30th.
Yes,
and
sir.
then I'm going to adjourn your hearing to May 30th, 2025 at 12 p.m.
Yes, sir.
noon. Okay?
Yes, sir.
Great. Okay, thank you. We'll see you then. Have a great weekend.
You
So
as well.
when you make that payment, then give it a couple hours and then call me, and we'll figure out what you need, and I'll do a conditional dismissal. Okay?
Okay, yes, sir. Thank you so much.
Thank you. Sandy McFiddish versus Donovan Alexander.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case is including court costs, is $1,685.
Mr. Alexander, how are you intending on getting that paid?
I could pay it off within the next 30 days.
Okay, so you're gonna need to try to arrange something with the plaintiff. How much can you pay before next week?
Up to $500-$600.
Okay.
Your Honor,
So you need to you need to pay $500 to $600 by the 30th.
By the 30th.
and if he does that, I'll give him what he needs on the balance.
Okay. All right. So get that paid. I'm going to adjourn the hearing to the 30th, May 30th, 2025 at 12 noon. Try to get that paid like the 29th if you can. And then when you come into court, it'll be something where you might be able to arrange so we can get you caught up. Okay.
Okay.
All right.
Okay. Yeah. Okay. Thank you.
All right. Thank you. You have a great weekend.
You too.
Sandy McFiddish versus Jalea Thomas.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case, including court costs, is $2,325.
Ms. Thomas, how are you intending on getting that paid?
I'm working on getting in contact with Hawk Housing Assistance for Washington County. That's the best thing I have right now. The house wasn't in the best living situation or suitable situation for me and my child. I asked to be released from the lease. It didn't really work out that way. I actually moved. So I have to work out getting the money to them.
Okay, so hold on. You moved out of the premises?
Yes, I left April 15th.
Okay, did you turn in the keys?
The keys were dropped off, yesterday.
Yesterday? Okay, here's what I'm gonna do. Because they're requesting only possession of the premises. You still may owe the money. Hold on. But you still may owe the money to them. But this case is for possession of the premises. So if they can verify that you turned in the keys, this case may go away. Okay, you still may owe the money, but.
Ms. Thomas, who did you give the keys to?
I was asked to give the keys in the mailbox for maintenance. Well, it was the maintenance, but for the leasing officer, like my property manager for that place.
So is the apartment vacant?
Yes, it's been vacant since April 15th.
You've got everything out of there?
Yes.
Your Honor, I think with that representation, and there's nobody else living there, correct?
No, I actually had been asked to get let out of my lease due to plumbing issues, and they wouldn't try to let me. They tried to make me stay until July.
All right, well, we can figure that out later. But Your Honor, I think I can just dismiss this case based upon her representation that she's out. And
all right,
even if we can't find the keys, I think we can take possession.
Maintenance knows. I want the picture. I can actually bring it, but there's a picture of the keys in the mailbox at the place.
Okay. You surrendered possession on the record here. They're going to dismiss the case, and they're going to take possession of the.
Okay.
Thank you.
No problem.
YPF 16 LLC versus Frenchie Alexander.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case, including court costs, is $1,350.
Frenchie Alexander. No response. If you'd raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
I'm David Fanter. I'm the attorney for IPF 16 LLC, and as such, I'm familiar with the books and records as they relate to this tenancy. In this case, there's rent owing in the amount of $1,175, court costs of $175 for a total of $1,350. We'd ask for a judgment for possession with a written 10 days if that amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested. Writ issue in 10 days. 103 South Huron LLC versus Aaron Emanuel.
Good morning, Your Honor. David Fanter on behalf of the plaintiff. The current balance on this case is $2,215, and he's already been approved for money from SOS for the full amount. So I think if we just come back next week, we can do a conditional dismissal. Maybe it'll even be paid by then, but even if it's not, we'll just do a conditional dismissal and resolve it.
All right, Mr. Emanuel, is all of that okay with you?
Yes, sir.
Okay. You guys made this easy for me. I'll adjourn this matter to May 30th, 2025 at 12 noon. Okay, we'll see you then, and hopefully we got everything worked out at that point.
Is that in person?
Yes, it is, sir.
Okay.
All right.
All right.
Thank you.
Thank you.
And Your Honor, I've made life tough on you sometimes, so I guess I made up for it at least a little bit today.
That's right. It balances out. All right.
I'll see you this afternoon. Thanks, Your Honor.
All right. Thank you. Thank you, Mr. Emanuel.
Thank you.
That's it for that block. Court stands in recess.
County of Washington, State of Michigan is not back in custody. They said
You may be seated. Calling all of the Arbour One West cases, but we'll call it under Arbour One West versus Rico McGuire.
that was written for the plaintiff, Your Honor. Alexander, I'm back for the defendant.
Good afternoon, Your Honor. Lauren Langdon for plaintiff as well.
All right. And where are we? I hate to ask.
No. So we had inspections on 5/20, the COC inspections. There were a number of items that we noted were failing for the inspections. They were supposed to come back out on 5/22 for reinspection. That was what we discussed at the pre-meeting. Property essentially they have to collect some items. And then we will be on the 23rd to discuss where we are with COCs. Nobody showed up on the 22nd. We had guys there waiting for the reinspection, ready to go. Nobody from the city showed up to do the reinspection. So that's first and foremost at this point. I'm not sure. We were provided no notice as to why they would not be there on the 22nd. We were expecting that to occur. So our guys are ready with items having been corrected from the original list, from what they noted on the 20th, and nobody from the city showed up on the 22nd.
Anybody know why they didn't show up on the 22nd, Mr. Parker?
Your Honor, the inspector was standing in Carol Punky's courtroom yesterday with counsel. So she knew exactly why I wasn't there. And because there was a laundry list of non-callbacks that we didn't have. Judge Punky has entered orders, or will be entering orders, we think, this morning, addressing the repair and inspection protocols for all of these buildings, because she's in jurisdiction over all of those. But we were called back out to say, this is fixed, now look at that, this is fixed, now look at that. We're going to continue to do our inspections, consistent with what we've agreed to do, and consistent with what we've been ordered to do by Judge Punky.
I was in court. Joe and Maya were in court as well. I know that the city has other inspectors. We were expecting an inspection to occur. We had guys ready. We had no reason to know that they were not going to show up. We didn't know Jerry or Joe were going to be in court. I don't know what there was no reason for them not to have showed up. I didn't notice that they weren't going to show up or to not arrange for other inspectors to come to the property to inspect, as we discussed.
All right. So I guess I want to make sure, and maybe I'll call touch base with Judge Punky. Is she issuing an order?
So
laying out everything? Because then I don't want to.
So Judge Kunke is entering an order, based on what she explained on the record. She will be entering an order that repairs be done in the property. Basically, as urgently as possible, get the repairs done. She will be entering an order, with regards to, tenant requests for relocation, things of that nature. Obviously, we don't know exactly what it's going to say, but, you know, this is what she indicated on the record. And as well as, you know, instructions to the city for timing of inspection. You know, took some issues with that. So she's going to provide 2 days of a request, and also, you know, make themselves reasonably available, for inspections if they're already on site or something, to inspect other work that may be ready. So she's going to be entering orders to that effect.
Do we know when she's going to do that? Or did she?
That we would possibly have a draft of that order at minimum today to see what it would look like. I think she's waiting on 1 or 2 exhibits that ourself and legal services are working on in connection with that. I know I spoke with Lou about it, so I'm not sure.
Yeah, we're working on a draft that we should have over by, you know, the end of today, and either today or I think next week she's planning to send out that order based on our draft and possibly yours that you send in, which will be covering, you know, what she's dealing with in terms of focusing on repairs, as well as how tenants might be able to get relocation assistance from their escrow amounts with the city, as well as whatever they pay to the landlord since September 17th, so that they can use that towards relocation for the tenants that are still, you know, in the property.
All right. So what I guess I would want to make sure of what's contained in that order, because we have, this court has escrow funds.
Right. So one of the items that will be in the agreement that I think is pretty undisputed at this point is that Arbour One will not object to the release of the escrow that's being held by the city or the court. I believe that the city's agreement requires that like all parties agree to some extent, so or something of that nature. So the order will clearly say that if they're electing the remedy to break their lease and move from Arbour One, that we won't object to those funds being released so that they can utilize that in finding whatever housing they may want to find.
Okay. So that will be contained within the order.
Yes, that will be involved with the order.
Okay. So what it seems like to me, and I guess what I'm going to do is I'm going to pause and I'm going to try to reach out to Judge Kunke directly and just see exactly what she's doing, because if she's going to assume all of this, there's no reason for 2 courts to be doing it, in my opinion. So
to the extent that there are folks on your docket that have been relocated, so one of the things that she indicated is folks that are being relocated are going to be paying half of their rent. I know that that's something that
paying half of their rent,
or what it would have been in Arbour One. So if folks are being relocated with the intent to come back to Arbour One, so temporarily relocated, basically saying, I want to come back to Arbour One once I can be placed in a building with the COC, those folks are being required to pay half of their rent during their relocation period.
I don't think that was part of this initial order, but she did bring that up as a possible thing she was considering in the future, and bringing up those issues of tenants relocated to the hotels. We did have Mr. McGuire, who was relocated to the hotel, and it seems he's been relocated back to his apartment.
Okay. So I guess I'm curious. So where would, and I realize you don't have the order, where would this half rent be paid?
To Arbour One. And so basically the argument was, you know, if we're relocating folks to a place that has a COC, whether it's, you know, whatever accommodations are ultimately determined, you know, Judge Kunke found it reasonable to say that they should be paying half of their rent. And so I believe that it is going to be in the part of the order. The last part that we talked about, no order, so that there's no direction to relocate folks, or something in the order that says folks can request to be relocated but have to pay half their rent. So I believe that she decided that was going to be a part of the order, so it's gonna be in there. I bring it up, and I know that this is something we talked about last time with folks that were on your docket having been relocated, establishing whether or not they intend to stay. And at that point, we should be discussing leases with those folks, or if they're planning to come back to the city side. And if that's the case, then they would be subject to that part of the order. So we just wanted to advise the court that that would be something that would be happening with those folks.
Okay. Got it. So for individuals, I'm just thinking about the cases that are before me. So for those individuals that relocated coming back, they would be, let's say their rent's $1,000. They would have to pay $500 to Arbour One.
Correct.
What happened? So, okay. What happens with the other piece?
The other piece of the rent.
Yeah, it's just not paid.
That is, I think that is just taken as a loss to Arbour One. I think the idea is that.
Got it.
Yeah, so it's basically everybody's paying half. That was the.
And I think it'd be specific to their portion as well too. If they're subsidized, they pay half of their portion, whatever that is.
Got it. They pay half of their portion, the subsidy.
I don't know if it was fully addressed.
Got it.
That's not something we got into.
Okay.
Up to the tenants.
Subsidy counts the hotel.
So I think what I will do, and so I could make this a very short hearing, it seems. Because it seems to me that if she's going to do all of that, that I'm not going to do anything and wait and see how it affects the cases that are before me. With reference, so for example, just taking by way of example, the escrow order, that really, I think in some ways negates the escrow order, right? For those individuals that would fall within that classification. Would you agree with that?
It negates your escrow order.
Yeah, because so if an individual is intending upon coming back, what the circuit court is saying, they need to pay half of their rent to Arbour One and Arbour One West. My order would indicate that they pay nothing, that they pay everything to the court.
Right, so yes, in essence, it would negate that, and then for the folks that are leaving altogether, they would get it back. So yes, in essence.
So of the cases that I have, how do I sort those people out?
For the folks who have been relocated versus, so we don't know the extent of everyone's desire to be relocated or staying permanently or temporarily. Some folks have also found their own housing at this point. So I think we would need to get a list of folks that have been relocated by Arbour One and, connect with them about, to the extent they intend on staying where they are, or if they are intending to come back to the city side. And if they're staying where they are, then we can deal with leases. And if they are intending on coming back to the city side, once there's a unit available that has a COC, then they would be required to pay their 50% of rent.
And do we have any people still in hotels that were relocated to hotels?
It's my understanding nobody is still in a hotel.
Okay,
Everybody's been relocated somewhere else.
I believe Mr. McGuire was relocated back to his original tenancy.
On the city side?
I believe so, yeah.
Okay. I can inquire into what's going on there. I don't know why it's back, what's happened there, but inquire and get the court information if that's what you're looking for, Your Honor.
Well, I just want to make sure that the 42 I have, that the orders that are consistent with what's been ordered at the circuit court. That's what I want to make sure of. And I guess we can do that sort of on a continuum basis, or what I could do and what I may be inclined to do is to just issue a stay on these proceedings before me and just await the final resolution in circuit.
Our next visit with Judge Conti is on
the 9th of June.
In lieu of a stay, could we perhaps adjourn proceedings for, say, 3 weeks to see we can sort everybody out? Who's going to do what, when, and where, and then we can maybe get some dismissals or CODs or settlement agreements in place.
Something in place on these. I'm not. That's fine with me also.
Okay.
I don't have a problem with that as long as the repairs are being made and the tenants. It sounds like through what Judge Conti's doing, the tenants are being taken into account in terms of what's happening. So,
I think the stay might work better because I just don't know how long this stuff in circuit court's going to go on for. But I think, once that's over, it's mostly going to resolve any issues that exist for all these tenants in this court, I believe.
well, why don't I do this? Why don't I adjourn this out to? Do I have it? I have the 27th.
27th of
June.
June?
Yeah.
Yes, sir.
All right. Why don't I adjourn it out to the 27th of June at 11? All right. Allow that to kind of take place if necessary, and then do that. All right.
Good. Thank you, Your Honor. In lieu of you having to bring your staff out on the 28th, I have a pamphlet showing a lot of
the things. All right.
So what Mr. Whitman is providing is photos taken of units in both of these buildings. At this point, we're dealing with situations where many of these units are ready to go, turnkey, ready. There are remaining items on the correction orders list, but not necessarily because they weren't corrected from the original list, but upon inspection, the city added more items to the list. And so we're obviously, you've made your decision with regards to having Hunky over here. This is, we're going to be arguing that these buildings are ready for the minimum temporary COCs. There's no reason that folks should not be in those units. And, a correction order for the units that still have some items that need to be done, list be provided of a 30-day correction order. These units are not to be occupied until corrected, and a temporary COC provided for the building. At this point, we need to get folks in these units that are ready to go. And
did Judge Conti address the issuance of the temporary CEOs?
About it, she at some point, it's been discussed. We didn't get a very clear. See, at some point she was inclined to an interim solution on the side of asking about the units that were ready to go. I don't think that we were able to explain to her that we would request a 30-day, correction order for some of these items that, the temporary COC could be in place, and that the correction order could say that some of these units should not be occupied until those items are taken care of off the list. But no temporary COC was ordered by Hunky at the time, but we also have these photos as of today. And so we're going to be presenting her with this same information that there's no reason folks shouldn't be in there. We're talking about items in some of these units that folks recently moved out. One of the things we talked about at a meeting with the city was that, what do we do if you come out for inspection and somebody moved out of their unit, 5 days before? Are you going to ding us because we're still turning that unit? A lot of these items that have been presented to the court in the most recent submission by the city are in fact some of those units and issues that we're still waiting on inspectors to come out and inspect. We still have inspections scheduled out for a lot of these units. So these items are not things that should hold up a COC or a temporary COC getting into the building. These items can still be corrected and it can be ongoing while folks are able to be in these units that are perfectly fine.
Okay. So what I will do at this point is I will cancel my visit on the 28th to the unit, given these being here. And also given the fact that it seems, again, I don't want to interfere with what the circuit court is attempting to try to do or try to do something that might be inconsistent with that. I think it's going to cover, it sounds to me, based upon what's being explained, is going to cover in the same way that I would the cases that are before me. So, okay.
Thank you.
So what I'll do is I'll adjourn this out to June 27th, 11 a.m. for a status conference.
And then for the tenants in this board, should they continue to pay escrow for June?
They should. Yes, they should pay their escrow for June. And then, because as I understand it, given what that order circuit court may look like, depending on then what that tenant decides, there's going to be some disposition of that escrow. All right.
Thank you, Your Honor.
Thank you, Your Honor.
The other aspect to it is, and I'd rather not refund it because it was the only way we were able to at least start the inspections. We still have that 65,000, I think it is, sitting here.
Okay.
And that, I mean, the intent of that, as I'm recalling, was to pay various invoices of the city regarding some of these inspections. So
they asked that be turned over to the city.
Well, that was the problem before. You want that turned over to the city, but when we tried to do that, we were told couldn't do that. They didn't want to just take a lump sum.
It would have to be applied to individuals.
Right, but nobody knew what those were. And so.
Why don't I suggest this? I can, obviously it's a holiday, but, we have to figure out what we're going to do with our escrow too, obviously. Have the, Mr. Myers break down the list, submit that list to the court, for, what costs go where, that might be the approach.
I mean, from our perspective, we would have no objection to the money just being applied to inspection fees. I think that that's been the biggest kind of holdup in getting some of these things done. And I think that that would help expedite making sure that things are done.
Right, no, so if anybody recalls the hearing, the sole reason that money ended up here is because there were these inspection fees due, and then there was an indication that further inspections weren't going to be done because these others had to be paid. And then I had to go through and try to figure out what the amount was that needed to be paid. And then I got a figure which was opposite of what I thought. I actually got a lower figure from the city than I did from Arbour One as to what was owed. So I took the higher figure, said, put it in escrow. Now it's there. When I also suggested that they just turn over the lump sum amount, that was sort of rebuffed because it was said, as I'm recalling, that they, whoever they are, don't like us to take it that way, that it has to be applied. So I don't have a problem if the city were to get to council get together while this is going on and come up with a list of what invoices are to be paid, give me a total at the end that's then to be released to the city. I don't have a problem with that, but everybody just needs to be in agreement what needs to be paid.
For the record, I think your recollection is accurate.
Thank you. Still haven't lost it, I guess. All right, so if you guys get that together, give me an order for release of that. I don't have a problem. I just didn't want everybody losing sight that that's still sitting. Okay. Thank you, folks. 27th at 11. Thank you.
There's a piece of wind that I had to take up the road.
I think ours is gonna be easy. Looks like it might be a default. Listen. All right.
We're seeing a district court for County of Washington State of Michigan is now back in session. Today's Simpson presides.
Maybe seated. Ann Arbor Commercial Realty versus Scott Sendis.
Good morning, or excuse me, Your Honor. Good afternoon. Tim Dabalski appearing on behalf of Ann Arbor Commercial Realty.
This is for Mr. Sendis. Looks like he went to the wrong courthouse.
Okay. You went to the wrong courthouse, says he's on his way. He's running late. All right. Sorry about that.
Nothing we can do.
Well, there is, but I wouldn't be the right thing. Let's put it that way. Kevin Coy versus Greg Munzer.
Ellis Freeman on behalf of the plaintiff.
Oh,
Mr. Munzer is his.
he's here.
Will you come up here?
Yes, right up here.
We're here in this session.
Oh, no, you're good. Here. Did you need hearing equipment?
No,
You sure?
I read
Oh.
lips pretty good.
What do you say?
I read lips pretty good.
Okay, we have equipment.
Yeah, no,
Why don't we give it a shot? It's good stuff.
I have on the face hearing. It's not bad hearing. It's just quite different.
Is that better for you?
Not really.
No? Okay.
It's too kind of artificial,
Okay, all right,
too
gotcha.
echoey.
Okay, all right. Very good. All right, where are we on this case?
Well, Your Honor, this is a termination case of month-to-month tenancy. There hasn't been a lease in effect in years. And there was a notice to quit given and the time has expired and we need possession of the property. We have some issues with Scioto Township with tickets and we need to get possession of the property. Simple as that.
All right. And Mr. Munzer, where are you on this?
Sir, I got sick. I brought in a doctor's thing. I was sick Wednesday. I was out, just recovering. This will be my first day getting back there. I need another week, but I can be out. When you first asked me last week, I didn't want to hold up the thing. I thought I could be out. I got sick.
Okay.
But in a clean, workman-like manner, I've got a production line. Things are going out. The storage is rented 1 mile from there. Ample room for everything. Most of it's out. I have a bug infestation. They were all airplane hangers. There was a 2-inch gap around the ceiling and the roof vent. It just brings in bugs.
All right.
Stuff is.
So if I give you to June 6th, you can be out?
Oh, absolutely, sir.
All right.
Yeah.
Then what I will do is I will find no tribal issue after hearing out granted judgment for possession to the plaintiff with the writ the June 6th.
Thank you, Your Honor.
And let me say finally that I was out there on 2 properties that are adjoining. It's the old Young Airfield Airport.
Okay.
Out on Jackson Road.
Yeah.
I've been out there 38 years. I just want to also say this one point. I am singly the person that has moved more trash off those 2 properties than everyone else combined. And when I lost the help of the senior parents due to retiree, and then the sons did not, they just said, hey, just let it go. And before that, I hauled them out. I got with the sheriff, whatever it took. I've hauled over 100,000 pounds off that property. And my stuff is clean, neat, and in a workmanlike manner. It's going out the door. It's my dream to be finished the second I'm done, believe me. But no one has worked harder, more. I just, in the end, I'll make a call to the and tell them how grateful I am. The sons and the township, if I had to bring them in front of the judge, I promise you, there were things that you wouldn't do legally.
Understood. All right. Thank you, sir.
Thank
You
you.
have a great weekend.
And
Feel better.
I can't thank you enough. My whole life is, going to a next step and.
Gotcha.
I
Okay.
Thank you.
Take care, sir.
Thank you.
Kevin Coy versus Tori McLean.
Ellis Friedman for the plaintiff.
They're not here.
No, sir.
Alrighty, you'd like to take a default. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
This is the same type of case, month-to-month tenancy. We know that the tenant is aware of it, and he's obviously just chosen not to appear. So we ask for default judgment. I'm fine with the same writ date.
Okay. Judgment to the plaintiff by default for possession. No redemption. Writ to issue June 6th.
Thank you, Your Honor. See you about 2:00.
Yes, sir.
Thank you.
And thank you for that that packet. That saved me a trip.
Yeah, it's pretty. It tells a lot.
Yes, it does. It does. S&C Holding versus Ashley Nicely.
Right, Your Honor.
Hello,
I'm here. Sorry.
Okay, I need the camera. Okay. The last time we were before the court, I think there was 24, 52, 56 that was owing. Where are we now, if anywhere?
Your Honor, there should be in the file a consent order for a conditional dismissal that both the defendant and I have signed on behalf of the plaintiff.
Yes, it was tucked in the back there. I got it. Okay, let me just take a brief look at this.
And then I did make a payment last night of $1,000.
Okay, so you made the $1,000 that's
I did,
referenced
yes.
here. Got it. Okay. This all makes sense. Ma'am, do you have any questions regarding anything contained on this?
No, I do not.
All right. All looks good to me. I will apprise you, and I will sign off on this conditional order dismissal. I will apprise you have 3 business days to think about it. If you believe that there's some legal reason, some confusion on your part, or some right you didn't serve, you'd have to file a motion with the court within that time frame. You understand that?
Yes.
All right, very good. This case is conditionally dismissed.
Thank you.
Sir. Town Center Place versus Viola Hines.
Good afternoon, Your Honor.
Good afternoon. Good afternoon, Ms. Hines.
Good afternoon.
All right. And last we were here, there was about 1,500 owed 1478.40.
SOS paid 1129 and Jewish Family Service paid the rest. And they're mailing the check to Town Center today.
Okay.
We haven't received it yet, so.
You haven't received it. So what happens with, they said they're mailing the check today?
Yes, Jewish Family Services. I was supposed to pick it up, but I didn't get away out there.
Okay.
So she called me this morning and said she would mail it.
So who's paying? You said SOS was paying part of it?
Yeah, they're paying 1129.
All right,
And-
do you mind if I ask?
No.
To determine, is that what you have, Amy?
Your Honor, I don't have a dollar amount. I just know that there's a coordination with JFS and SOS, and what she's speaking about is that checks don't need to be, make sure that it's in transit. But
Which check?
the JFS,
JFS check. Okay, but you do see that the whole,
that they're gonna resolve it with both of them.
with the two checks. Okay. So, given that representation, council, what I'm gonna do, and hopefully then this can be dismissed, let me adjourn it out a week, since we won't go into another month. And hopefully this will resolve itself. So, May 30th, 2025 at
1 p.m.
1 p.m.
Okay.
And hopefully those checks will get there. And you said so the Jewish Family Services, they've now mailed the check.
Yeah,
As opposed
today.
to you getting, okay, all right,
Yeah.
okay. So then we can see where we are on it, do what we
Thank you,
need
Your
to.
Honor.
Okay.
All right,
Thank you. You have a good holiday.
You do the same. Linden Park Apartments versus Brittany Edwards.
Good morning, Your Honor.
Council, state your
Member
opinion.
Andrew Curtis for the plaintiff. I'm sorry, I don't have much of a voice.
Okay, it's all right. A lawyer without a voice. I don't know if that's a good thing or a bad thing. I don't know. There are days I would appreciate that. Anyway. Miss Edwards?
Yes, hold on 1 second. I'm trying to turn my camera on, but it's not working.
Okay, there you are. We've got you. Okay. We were at 3,059.15 last time we were here. Has that changed at all or where?
Your Honor, the
Yes.
numbers, yeah, the rent to retain possession is $1,900. We have costs of $159.15. So we would be seeking a possession judgment of $2,059.15.
Okay, so basically paid 1,000. Is that correct, Ms. Edwards?
Yes.
Okay. And what is did you have a plan for that 2,059 or?
Yes, I do. Just like I said before, on the first court date, I can pay on the 28th, the full balance.
So you can pay everything on the 28th?
Yes, I can.
All right, since you paid the 1,000 and got that in, and you can pay it on the 28th of this month, I'm going to adjourn this out to May 30th, rather than give you a judgment, 2025 at 1 p.m. All right. And typically what happens, Miss Edwards, if you get everything paid, you just got to make sure everything's paid. They're going to dismiss the case. Okay.
Okay, no problem. I do have a question though. On that day, I do have a surgery scheduled at the same time that you want to do the court date. So if my balance is paid, do I have to get on Zoom again?
No, if your balance is paid, then, and everything's paid off, just make sure that it is.
Okay.
Then if you don't appear, there's nothing for anybody to do except me. And let's dismiss it, okay?
Okay, thank you so much.
All right, thank you. Be well, please.
You too.
Thank you, Your Honor.
All right, thank you, sir. And then he showed up. Okay. Then I'll just wait for a moment. We can go off for a second.
United District Court for County of Washington, State of Michigan is now back in session. Jay said,
You may be seated. Here we go. Court has called the case of Arbour Commercial Realty versus Scott Sendes.
Good afternoon, Your Honor. For the record, Tim Dabalski appearing on behalf of the plaintiff, Commercial Realty LLC.
Scott Sundays, Your Honor.
All right. And where are we on this, John?
Well, I thought we were going to be able to resolve this, but we're unable to. So I guess we're going to have a hearing, Your Honor.
So what's the issue?
Well, I'm not really quite sure. The tenant wants 6 months to move all of the stuff out. That's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10 days statutory period. And the other thing is that he feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
Correct.
Those
Yeah,
are,
we had a verbal agreement that if I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
and it's my client's position that no agreement was made, and even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
So you're not disputing that the rent's owed?
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement.
But I'm in the process of moving out.
But really, guys, I hear you. You guys can keep repeating it, but
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move, right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them. But I've tried to work with them. I even offered another solution to conduct a liquidation auction. But I said even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, and I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time, even after I liquidate a vast majority of the stuff. It's still going to take time to remove the junk, and I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls. And I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So I don't know I think that's what you're referring to,
I
correct?
guess I just meant I wasn't aware that, the person that I was talking to isn't actually running the operation anymore, so, when I was told, I won't charge you any rent if you can move everything out, you know, and at the time I talked to him last, I didn't give him,
Yeah,
a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the
Which
process.
means if you haven't moved, that means you still owe the rent. Right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with stuff. So it's not, you know, it took several years.
I get back to my same question. For you, how much time are you looking? 6 months is not gonna happen.
Okay.
So here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not gonna be near 6 months.
Okay.
And so if you guys can't decide, I'm gonna pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are gonna have to decide. It's gonna have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was, they're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not.
How much, what would be the fastest?
I mean, 4 months, is that agreeable?
No, that still puts us in the same position.
It's, like I said, I've probably moved half of it out within the past, 3 months. It's gonna take, I would say, at least 4 months, realistically.
I mean, no.
We'll let Your Honor make that decision.
That's really don't want me to do that. Nobody gets happy then. But listen to everybody. As to the issue of possession, I'm going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor.
What do you mean you haven't received any summons?
The only summons that I received was the one on the tape to the door, and
that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was riddled.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive?
Yes.
I'll tell you what. Here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it and I'll give you a copy. Thank you.
The judgment up at the counter.
Yes, get a judgment out at the counter, sign it, and then get it all prepared, and then I'll do that.
Thank you, Your Honor. Hold on.
Arbour Woods versus Masheri Taylor.
Good afternoon, Your Honor. Sydney Fine, LMP 86316 for the plaintiff.
And good afternoon, Sydney. Your name?
Shari Taylor.
All right. And where are we on this case?
Your Honor, I believe that last week was the hearing on the motion to set aside the dismissal and reinstate case, and so you adjourned this for a second hearing. My understanding is that she was expecting to get some payment from some agency, so I would inquire as to what the status is about that.
Right.
We haven't heard from them yet, but we're still waiting on the, waiting on, what they say, how much we're getting. And I won't get paid for my job until next Friday, I believe. And I had called them to see if they can work with me, but the office said they won't.
Hold on a moment. So first thing, let me start here. There was 2,053 that was supposed to be paid May 16th. Did that get paid?
Your Honor, so I do show that that was posted to the ledger on May 21st. Would you like me to run through what's currently due?
Pardon?
Would you like me to run through what's currently due?
Yes, please.
Yeah, so there's rent due of $9,421.78, court costs of $185 for a total of $9,606.78.
$606. What was the cents? I'm sorry.
78 cents.
78 cents. Okay, so you did make that payment.
Yes.
Okay, because it dropped from the last time that we were here. Okay. And then how much were you supposed to receive from these other individuals?
I think it was 6.
6. I remember you saying 6 because I thought we were still going to be about 3 short.
Yeah.
With everything. But
I think
then you say you get paid on the 30th, and how much is that?
Depends on what, how long the job was, this whole entire week. But, usually it's about 3 or maybe 4.
3 or 400. Okay, but that doesn't help kick this balance up because even if, let's say it was the maximum of 4, I'm still $3,200 short.
Yeah. And I was trying to, see if they could work with us because I know I can pay next month's, rent on time. It's just the back rent I need to pay off. And I was trying to work with that, see if I can.
Okay, but here's my problem. My problem is this 6,000 or thereabouts, we don't know when that's coming or if it's coming.
Yeah, I don't know.
Right. And so if the 6,000 doesn't show up, then you don't even necessarily have a plan as to how there's 9,000, almost 9,500 gets paid. Right?
Yeah, but I was getting help from family and friends with the rest if the 6,000 came.
All right. Well, I don't really have anything to
And
try.
I have
Go ahead.
And I have an appointment with Hawk coming too.
Okay, but here's gonna be the problem. And I think you might have mentioned something about Hawk before.
Yeah.
If the 6,000 was paid, right?
Yes.
And you said that came in, and then you get to, say you got 400 from your check. So you knock that off. Then I'm at about $3,200, not going into June. And then if you can find a way to get 200 and Hawk had the money, they would pay 3, but you have to get this balance under 3,000 before Hawk's going to do anything. Right?
Yes.
So that's the problem. It's the logistics of as to when these payments are in. But even at this point, I can look at all of that, but at this point, I don't even have the 6,000. And that's going to be the biggest chunk of all of this. All right. So who's supposed to pay the 6?
My mom knows the name of the people. I can't remember it.
Mom here. Come on up. Who's supposed to pay that?
It's through the agency, it's a community, health agency that's my cousin. We will be over her health.
Pardon?
Her health care, to help her in the house. So they giving us a lump sum because they owe us for that. That money is coming, so we should know some by next week with that, because we talked to the lady the other day.
Okay, all right. Okay, here's what okay. I hear you. I don't have anything to try in the case. Okay, I reinstated the case on this. You made that one payment. I think if the 6 came in, maybe your landlord will work with you to try to do that. But even if the 6 comes in, and then you can get another 6 and work with Hawk, you might be able to secure that other 3. You follow me?
It's 9,000,
It's
right?
9, but if the 6 came in, then that would take you down to about 3,600.
Right, and
Hawk's maximum is 3,000.
Correct.
But that, you'd have to get all of that accomplished before June kicks in, because June is gonna kick that
Yeah,
balance.
that's the problem. Their dates is out far, so, and you usually can't get a
Right,
date
but
without a.
Hawk isn't gonna do anything.
Correct.
They can't even make a promise to you, because you have to, you would have to show them that this balance is gonna be under 3,000 or 3,000 or under. Right? I mean, that's gonna be the problem. All right? But I don't have anything to try here, so I'm gonna grant a judgment for possession to the plaintiff for the $9,606.78. What I will do is give you a little bit of additional time with a writ to issue June 6th over the objection of plaintiff. So if maybe, and by putting it out to the 6th, if you can get the 6 into them, get to Hawk, let them know the position that you're in, and then make sure that your June rent gets paid on time.
Correct.
And then find 600 to get yourself at that $3,000 threshold, and just hope and pray that Hawk can come through for you.
Yes.
You can do it. That's the only way I see this possible work. Okay, folks? All right. So that's what I'll do.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of Arbour Woods versus Felicia Hugan
City Fontanelle.
and Reginald. I'm sorry, and Reginald Hugan.
City Fontanelle for the plaintiff. Your Honor.
Pardon? The Hugans are not here, which is odd. Well, would you like to take a default?
Yes,
Do you
please.
solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. Your Honor, there is current rent due of $1,331.91. Court costs of $242 for a total of $1,573.91. And I would request writ to issue after June 2nd, 2025.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you.
Thank you. Court calls the case of Arbour Woods versus Brittany LaFloria.
City Fontanelle for the plaintiff, Your Honor.
Hello.
Hi.
What's your name?
Brittany.
And what is plaintiff's claim on this case?
Your Honor, so I believe that Ms. LaFloria has been speaking with Ms. Dornbush from my office, honestly, quite a bit today. And so we did discuss some concerns she had with the balance. And so what I'm showing for rent is $342.30, court cost of $186 for a total of $528.30.
$528?
Yeah, and 30 cents.
That's owing.
Yes. That is
As
what
of our agreement from.
Yes.
Hold on a second. Well, She's made a heck of a lot of payments then.
Your Honor, so if I may, there haven't been
Yeah.
payments made. There's been some credits that we've discussed, and so my client is going to be providing credits to the ledger, and so that's the balance that would be due after the credits have been applied. Miss LaFloria stated that she could have this paid by June 2nd, I believe, and so what I would request is just a judgment today with her to pay that by
For
June
that
2nd.
amount. Is that correct? That you can have this paid by then?
Before then.
Before then?
I couldn't make it today because they have to adjust the ledger online, so I couldn't make the payment yet until they come into the office after the holiday.
Okay, got it. Okay. So what I'm gonna do is I'll find no tribal issue after hearing. I'll grant a judgment for possession for the $528.30. All right, and with a writ to issue June 2nd or thereafter. So you have that time to get it paid.
Okay.
All right?
Thank you.
You have a great weekend.
Thank you, Your Honor.
Court calls the case of Arbour Woods versus Dominique Lucas.
Cindy Fontanella for the plaintiff, Your Honor.
Hello.
How you doing?
Okay, what's your name?
Dominique Lucas.
All right. Okay, what do we have her balance?
Your Honor, I'm showing that her current rent due is $3,237.16. Court costs of $186 for a total of $3,423.16 currently due.
All right. And what do you have to say? Did you make you didn't make the payments I said you were gonna make?
No, I had some issues come up, so I had to use the money for my car.
This is your monthly rent.
$14.49.
How are you gonna try to get this paid?
I have 700 today, and I can make the rest of the, what was that, be 2736, I believe, by June 4th.
Okay, so you're saying you can get this total amount paid by June 4th?
Yes.
Okay, so here's what I'm gonna do, young lady. I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment for possession for the amount of the $3,423.16. And writ issue, I'll make it June 6, 2025. Over plaintiff's objection, maybe. All right, so you got to the 6th to get all that.
Okay.
I would get, if you got the 700 day, get that into them, so you get that balance now.
Okay.
This judgment doesn't include anything having to do with your June rent.
Okay.
It's just the back portion.
Okay.
Okay?
I got a question for you.
Okay.
I
have an answer for you. No, I don't know. Maybe I don't.
I seen you in February. When I seen you in February, did you include March's rent into February?
Whoa. You're okay. I would love to be able to answer your question, but I've probably seen, I don't know, how many cases.
Yeah. Okay.
So what was the date in February? You know?
I don't remember the date in February, but I know I had to have everything paid by March 10th, which I did. I don't remember the date in February.
Just a second.
Was it February 28th?
Give me just a second. Let me see what I can find in our system.
She was here in January.
Was it January?
January
24. Okay, I don't see a judgment in February. I see a judgment in January.
Okay.
Yeah, it looks like there was a judgment entered on January 24th.
Oh, sure.
I'm her mother. Okay, come on up with your daughter. What are you, because you're gonna sit up there and yell at me from the back. What's your name?
Luella. Hi. I think the questions that she's asking when she was in here in January, from her understanding that the February or whatever following month was included within that balance.
Okay.
And I think this is where she's getting off a track.
Gotcha. So I can't say for sure, but I can tell you that generally, if the judgment was January 24th, February rent was not included in that.
Okay,
Okay, that would only included what was due then.
okay,
Okay,
okay.
all right.
That's good with me.
See, it's good that you have your mom, because I understood what she said. I didn't know what she said. No, I'm kidding.
Thank you.
All right. Thank you. You take care. Court calls the case of Arbour Woods versus Alicia White.
Sydney Fontanella for the plaintiff.
And Michaela White. Neither one are present. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There's rent due of $3,400.56, court cost of $242, for a total of $3,642.56, and I would request a writ to issue after June 2nd.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested. Writ to issue in 10 days. Northfield Estates versus Carl Riemann.
Sydney Fontanella for the plaintiff.
That you, sir?
I'm Carl Ryman.
All right. All right. This is a termination case, and you adjourned us out for you to seek the advice of an attorney. So where are you now on this case?
I adjourned it to seek advice. I failed to get any attorneys to get involved. I got warning that I'd be postponed a week last week. And then that never followed through to get anything more further down. I just counting on my Apple phone for a computer these days. I'm just, at a lurch of, was just living as feeble as I am these days with, my brother just got committed to hospice this week, and I'm just, mixed up with, just trying to pay off, see how I survive my sewer bill or my gas bill, I should say, for over the winter time. And then the surprise of Northfield Estates not accepting, refusing April's rent. I never got, I guess I get answers. I guess anything to do with the management, it's like answering a question with a question. And it's just like, change the subject to just keep me confused is all. That's my best defense I have with my management. And the just fix this, fix that, like I'm just a, bleeding deacon of money. And I'm just trying to balance out, that they say things, they like my first initial leak was a bathtub leak, and the water got in, and around to my back porch enough to surge the porch up, so my porch is pushed up in the back, and that with the winter freeze, and so just that's just all of a sudden that just crushed that, and it's like, gee, I know I have some ideas to fix it, and it just. I just don't, I just stay terminally confused. I don't know how to, my best defense is confused. I'm seeking lawyers. I guess I would just get real frustrated with getting callbacks and any direction to go fixing my, I guess the, latest one.
But they're alleging they're trying to terminate your tenancy. What's your defense to them terminating your tenancy?
I guess what's I guess so just what's my response to that? I guess fix my front door. My front storm door was their latest thing that they put to be a diligent thing to fix. And they're saying that when when it was still frozen in the ground because the hinge broke off. And I'm gonna fix that, and then what's fix my skirting and
have you got all of that? You don't have it all fixed.
I don't have it all fixed. I'm plenty busy with trying to find my balance of money, and my older brother, last of my family to be on this side of the grass that has been kind of troubling me. And I guess, just communication with the management it's just answer a specific question or ask a specific question and it gets switched to something else. And it gets so frustrating. It just helps encourage ADD or something. I don't know. That's my nicest way to put it, I guess.
Your Honor,
So
if I may.
Sir, yes, go ahead, Ms. Fenton.
Thank you, Your Honor. So this is a termination for just cause based on failure to maintain the appearance and yard upkeep. I have received updated photos from my client as of 2 days ago. The home and site are still not up to community standards by any means. I do show that Mr. Ryman painted his home. That it's still not up to standard. The skirting's not fixed. There's a ton of trash on the site. There's a ton of trash on the deck. The deck still needs to be redone. There's a lot of condition issues that are still existing as of today.
Well, my
And you're not disputing that, you're just
no,
saying.
I'm just, first of all, I guess the paint was painted when my wife was still alive, that, she passed away early 2022. And and we went through the process, a park approved color and painted that. And then, I had some
But
T111.
sir, you're admitting that the skirting isn't up. And there's
the skirting.
issues with- I think you mentioned some.
Skirting in the back was not really visible. It's
still painted.
Yeah, it's
all right. Look, sir,
I guess excuse me, Your Honor, I guess the park approved color for my paint, I guess I just want to add in, like the modern day, I guess I'm surrounded by aluminum siding mobile homes and I have T1, wooden siding one, and the park approved color thing, it's like, gee, no, we went through the process to be approved the color to paint it. And so it's just changed the rules, gets to be just difficult. I don't know, move the goalpost. I said it right to Jeannie's face, the manager, change the goalpost, makes it a little change the goal line. It just keeps me in everlasting confusion. I don't know.
all right. So here's the deal. I don't see anything I can try. You've admitted that you haven't kept the property up to standards regarding everything. And I'm not even necessarily talking about the paint. I'm talking about there are other conditions on the premises. So I'm going to find that there's no tribal issue for the court regarding that. I'm going to grant a judgment for possession and termination of the tenancy with the writ date of June 6, 2025. What I suggest you do, sir, is, you either have to move or you're going to have to figure out a way to get out there and try to get the done and deal with management.
I guess then she can reverse this.
Well, they can, if they choose to, they can work with you. But I think quite frankly, sir, there are things that you're going to have to do to try to make sure to get that property up to community standards. Thank you. Northville Crossing versus Nicholas Buckland.
Sydney Festival.
And Brittany Moore.
Sydney Festival for the plaintiff, Your Honor.
Buckland, Moore, no response. You may proceed.
Thank you, Your Honor. I would request a default judgment. There's current rent due of $806.67, court costs of $246, for a total of $1,052.67, and I would request writ to issue in 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Northville Crossing versus Ardell Carson.
Sydney Fentanyl for the plaintiff.
Ardell Carson, no response. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There is current rent due of $2,131.75, court costs of $190, for a total of $2,321.75, and I would request writ to issue in 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested, which issue 10 days. Northville Crossing versus Faithland, is it Lefker?
Hi,
What's your name?
Faithful Lefker.
All right. More importantly,
Charlotte.
Charlotte?
Yes,
Okay, how old's Charlotte?
she's 2 months.
2 months, okay. All right. And how much do we have owing?
That there's rent due of $1,864.20, court costs of $190, for a total of $2,054.20. I do believe Miss Lefker was looking into getting assistance, so I would just inquire with her what the status is of that.
My notes indicate, well, she was gonna pay $750 that day. Did you get
I
that?
did. I actually have the receipt for the cashier's check as well if needed.
Okay. And then I think she was getting help from her church.
I'm getting assistance from a local parish, and I also submitted my paperwork with MI Works. I'm just waiting on the caseworker to update me on what next is happening.
Okay. So Ms. Fontenot, do you see a $750 payment?
I do not, but Miss Lefker, when did you drop off that payment?
I dropped it off. It was that day. I dropped it off on May 16th.
Okay.
I didn't see it in the portal either.
Yeah, right. And the only reason I'm asking is because the balance hasn't moved.
So the balance does not reflect a $750 payment. My client's, the office is closed today, so I could not confirm whether any payment was received today
Got it.
or before this.
Oh, okay. But she has a receipt. You just hold on to that.
Okay.
You told me you were gonna pay it that day, and if your receipt, it says the 16th, that's it. So that would bring it down.
1329 is what I was under the assumption that was due, which I will have by the 30th.
You'll have that by will you have that by the 30th with the help from the parish, or?
Yes, with them. And then if they're paying 600 of it.
Who is?
The parish.
The parish is gonna pay 600.
And then if MI Works isn't able to cover the other half of it or any of it, my grandma was actually gonna help me get that. But then I have next month's as well on top of that. I get paid on the 30th, so I will have that.
Okay.
I will have.
Tell you what I'm gonna do, and I'll do this over the objection of plaintiff. I'm gonna adjourn it out a week. Let her give a shot at getting it done. So May 30th, 2025, what time?
2 p.m.
At 2 p.m. Can you get? Now, the parish, how will they be paying? Will they be sending it directly to the landlord, or will they be sending it to you to get to the landlord?
I believe they send it to me. I asked, but he wasn't clear on it.
Okay.
So.
And then you'll obviously have your paycheck. Can you get that all paid before, say, on the 30th?
If it has to be a cashier's check, I could definitely try my best. I just have to get to the bank to get the cashier's check and then.
Okay. All right. Give that a shot. I'm gonna give you a week to try to get it because you at least have a plan here.
Yes.
I think that 750 goes in, so her balance is probably around
It's
1,300 or something.
$1,300-ish. Yeah.
Yeah, and so we'll give you a shot to try to get that paid.
Okay.
Okay? We'll do that for Charlotte. All right, okay. Take care.
You too.
I help her with the door, you just went, man, really?
I got it. I'm just.
No, I know, you're pretty adept at that, but could've. Okay, no, man, I know, that's not your job, but geez. Scio Farms versus Jesse Steenberg and Brent Steenberg.
Sydney Fontanella for the plaintiff, Your Honor.
Steenberg, nobody's present, you may proceed.
Your Honor, there's rent due of $96.65. Court
Excuse me?
costs $96.65. Court costs
Okay.
of $230. Of $326.65. I would request a default judgment with writ to issue in 10 days, but I would also understand if you wanted me to put in there no writ without hearing.
No, yeah, that's it. I will grant your judgment by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days, no writ without a hearing.
Thank you.
You're welcome. Court does call the case of Spice Tree Apartments versus Cameron Hall.
Sydney Fontanella for the plaintiff, Your Honor.
And Letwana Mitchell.
Your Honor, Ms. Kingsley and opposing counsel Gail Rosen submitted a consent judgment with a vacate date of June 6th today. I'm guessing it probably hasn't made it to you yet.
No, it has not.
That has been signed.
But there's a consent judgment coming through?
Yes, there should be.
All right. Was this a student? Yeah.
Yes.
All right. Then I'll indicate there's a consent judgment to follow, and I'll enter it when it comes in.
Thank you.
Thank you. Whitaker Oaks versus Kathleen Short.
Sydney Fontanella for the plaintiff, Your Honor.
And the second defendant of Brian Pollard. Short, Pollard, neither is here. You may proceed.
Your Honor, we've actually had communications with them today. We did agree to a conditional dismissal, and they are going, let me pull up the terms that Miss Dornbush sent over to me. Pursuant to paragraph 3 of the conditional dismissal, the action is converted to a termination of tenancy. Defendants will vacate on or before June 2nd. Defendants will be deemed to have vacated when keys are returned to plaintiff, and any personal property remaining at the time are abandoned and may be disposed of as plaintiff deems fit. Both of these defendants gave our office permission to sign and submit the agreement on their behalf. I'm not sure why they're not here, but that is my intent.
All right. Then I'll indicate that there's a conditional dismissal order to follow, and I'll sign that when it arrives.
Awesome.
Very good. That's it.
Thank you, Your Honor. I don't know that I'll see you again, so I will see you probably this fall.
Okay. All righty. You're taking care of yourself though, right?
Yes, due with baby in a month, so.
Is it a month?
27 days. I'm not counting down the days or anything.
Well, young lady, congratulations to you again. All right. And I hope everything goes well for you and baby.
I appreciate it, Your Honor. Have a good weekend.
You do the same. Take care. Court stands in.
All right. 14A District Court for County of Washington, State of Michigan, is not having session. The applicant Judge Simpsons.
You may be seated. Court does call the case of Barnes and Barnes versus Quintavious Scandrett.
Cole Friedman for the plaintiff.
And there's a second defendant. And Christopher Mayo. Why not?
Your Honor, I've discussed this matter with the defendant, and he's got some scholarship money coming in, some pay. Keep your hands here, Brian. Get some pay coming shortly. He's good for it. So could we just have a 2-week adjournment?
2 weeks. Is that fine with you, sir?
Yep, perfect.
I need you to state your name for the record.
Christopher Mayo.
Thank you. All right, I'll adjourn it to June 6th. We don't have 2 weeks. That's right. All right, I can do the 30th or the 13th.
The 30, what time do you get paid on 30?
I get paid on the 30th at like 3 p.m.
No, we'll go out. We can go out.
Oh,
So the 13th, yeah, okay.
June 13th, 2025, at 3 p.m. All right? All right, take care of yourself.
Thank you. You're welcome.
Barnes and Barnes versus Marcus Hargrove.
Now let's wait for the plaintiff, Your Honor.
Marcus Hargrove? No response. I'd like to take a default. If you would, raise your hand.
You know, Your Honor, I don't want to take a default.
Okay. What do we want to do with this?
He signed a conditional order yesterday and, so.
But he's not here. He signed one.
Yes.
All right. And those terms are?
We'll dismiss and he'll make payments to the portal of 700 by the 30th, 200 on Tuesday the 9th, and 1075 by June 20th. Total amount of 1975 represents the past due balance and the amount for June.
Got it. Well, I will, if you have that signed, I will enter that conditional order dismissal, the court specifically finding that's more favorable to the defendant or judgment by default.
Thank you, Your Honor. Thank you. Thank you, Your Honor.
All right. Thank you, sir.
Have a good weekend.
You can say. Inventory Place versus Shaquinice Gardner.
Chief, for the plaintiff.
Yes. Gardner?
Yes, hi.
Hello. Okay, I'll need a camera. Where are we on this case?
I'm not sure if it's gonna work. I'm in the hospital. I had the baby.
Oh, okay. You had your baby?
Yes,
Boy or girl?
it was a boy.
Little boy. Okay. And mom's doing okay and baby's doing okay?
Yeah, I'm doing okay.
All right. Then you don't need to turn your camera on. You're good.
Okay.
All right. What are we doing?
Balance is 2515.81, which is same as it was last week. And I have a note that she was gonna pay 400 and a payment this week and is applying for SER, but the payments did not materialize, and perhaps we can get confirmation on the SER.
All right. Ms. Gardner,
Yes,
have you gotten any information on your SER?
they told me that the SER was denied because I'm on maternity leave, and I do still have the 400. I just wasn't able to turn it in because I was in the hospital. I'm in the hospital.
Oh, okay. You were in the hospital. All right.
Yes.
Okay, but the SER was denied?
Yes.
Okay.
I also reached out to Hawk.
Yeah, did they give you an appointment yet or say
No.
anything to you?
But the lady told me that she wasn't sure if I was going to get an appointment because the same thing, me being on maternity leave, I may get denied.
So you go on maternity leave and everybody denies you? Is that?
Yeah, I guess so.
All right. That makes sense. What would you like to do?
Well,
When are you expected to, get out of the hospital, Ms. Gardner?
Hours, I just had them.
Okay.
Yeah.
Then, over the plane, if I'm gonna dread it out a week. But you get your bearings and try to figure out what you're gonna do. So May 30th, 2025 at 3 p.m. Okay. All right, Ms. Gardner.
Okay, thank
Yep, oh, hold
you so
on.
much.
I just want to make a suggestion that Ms. Gardner would like to reach out to Legal Services of South Central Michigan. See if they might be able to assist with this eviction prevention.
Okay. All right, did you hear that, Ms. Gardner, at all, or no?
Something, just a little, not all of it.
Okay, if you can reach out to Legal Services regarding eviction prevention programs.
Okay.
Okay, do you have something to write with? I'll give you their number.
Yes, 1 second. Okay, I'm ready.
Okay, it's 665
Okay,
6181.
8-1. All right, thank you guys so much.
All righty, thank you. Good luck to you.
Thank you.
Peninsula Place versus Brianna Johnson.
James Fink for the plaintiff.
Hello, what's your name? Thank you. All right, what are we doing now?
I think her application for, you came out just as we were wrapping that up, so we could double check with Miss Amy.
Okay.
Your Honor,
All right. Would we expect to get an update at some point on this?
I'm reaching out.
Oh, okay, why don't I do this? Let me just adjourn this out a week. And then we'll see exactly where we are. It'd be May 30th, 2025, 3 p.m. Okay, all right, thank you.
Thank you.
Peninsula Place versus Juwan Carlton.
Hello.
Hello, okay, oh, there he is, okay. What's owed on this? I had 307034 last time we were here.
The balance today is $3,070.34, which is the same as it was
the last time,
last week.
All right, Mr. Carlton, how are you gonna try to take care of this?
My financial aid disbursement date is the 29th. So it'll probably take a couple of business days for it to go through my account, and then I'll just take care of it. I've been approved for like 10,000. So I should receive 7, I think. And then 5, another 5 or so. So 12 in total. Because I have some scholarships and grants as well.
Oh, okay, so you're a student?
Yeah, at Washington Community.
Oh, okay, did we talk about that the last time? So you're waiting on your.
Yeah, my financial aid.
Yeah, I got you. Okay. And they said, what day did they say it would come in?
The 29th, it gets sent out from the school, so it may take a couple days. That's a Thursday, so it may take probably till the 6th, I'm assuming. Just to give it an extra couple days to go through or get cleared, but sometimes it's immediate. Sometimes
Okay, how much is your monthly rent?
I think 1,079 now.
1,079?
Yeah.
Excuse me.
Okay.
The rent's 1,049, but then there's some other things
Charges.
added, utilities and insurance.
All right. Well, I mean, I could do a judgment to the 6th and give them to the 6th to get it paid. My only concern, the students know, or tell the students checks are gonna be, and then they don't.
Or,
Yeah.
um,
Whatever your pleasure. I mean, I could give him a judgment, just extend it out to the 6th.
then we don't have to come back.
Then we don't have to come back. Okay, so sir, what I'm gonna do is I'm gonna do no tribal issue. After
Okay.
hearing in this case, I'm gonna grant a judgment for possession for that $3,070.34. Okay?
Okay.
Instead of you having to pay it by the 2nd of June, I'm going to extend that. I'm actually gonna go to the 9th, that next Monday,
Okay.
to June 9th, 2025. The important thing for you is that does not include your June rent. Okay?
Yeah, no. Yeah.
So it's a benefit to, I guess, to take the judgment now, but also just to let you know that you'll still owe your June rent. Okay?
Oh yeah. I got a new job, so new check will come too, so it should take care of all that.
Okay. All right. We're good. All right. And I've signed that judgment, sir. Okay? Thank you.
Thank you.
Peninsula Place versus Rahalia Jackson.
James Fink for the plaintiff. She's here.
She's
And her app is still pending.
Hello, what's your name? Her application with Hawk.
Yes.
Okay, so here's what I'll do. Let me put it out a week, see if we get some information on it. May 30th, 2025 at 3 p.m.
In person or online?
in person.
Okay.
Okay?
I have 2 jobs, so I'm like, I have to, let me.
Seems like you'd want a break. You might be-
I do work that day. At 3
She's too
p.m.
busy to come, Your Honor.
Exactly at 3 p.m.
You work at 3 p.m.? Okay, if you fill out a Zoom form, I'll let you appear via Zoom.
Okay.
Okay?
I just.
You can get it up front.
Okay.
You have one? Yeah. Okay, we'll give you one. Glencoe, just fill that, you fill it out and give it back to us now. We'll be good. Okay? Glencoe Hills versus Tillman Commons. Comments? No response. Like to take a default, you can raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir, I do. Your Honor, this is an action for non-payment of rent. This defendant owes $2,717.15 in rent, 2717.15. The costs are $171. We request a default judgment for possession only in the amount of $2,888.15.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days. Gulfside Lakes versus Betty Nichols.
Hi, Your Honor. I am here. I am
Okay.
at Carmano's. I'm in Carmano's doing chemo and I can't come on camera.
Okay, all right, that's fine.
Okay.
It's okay. All right. And what's owing on Ms. Nichols?
This is Ms. Nichols,
Yes.
$4,836, excuse me, 4846.31.
So the earliest now is June 2nd. I opened up a new bank account and they did not tell me when you deposit a live check, they hold it. You can't withdraw for 30 days. So June 2nd, my money will be released to me. However, oncology is suggesting that I surrender my keys and vacate. We did find a facility for me to go to, but the bed won't be available June 2nd. And I think I can have someone move my belongings out on June 2nd. I could turn my keys. However, I still want to pay the balance in full. It's going to get paid regardless, but I don't want an eviction on my credit report because I'm beating this. I'm going to beat this. Once I'm done, I do plan on buying a house, but I don't want an eviction on my credit report.
Got it.
So I have the funds, Your Honor. I was on a medical leave, and until oncology sent them, it was back pay. My back pay is $18,000 for 2 months that I didn't get paid. Being that it was a live check, Citizen is they won't let me withdraw until 6/2 because I opened up the account on 5/2.
Okay. What do you want?
I couldn't hear most of what she said.
She doesn't want a judgment. She's got about 1,000 that's in her account, but it's a live check, so her bank won't release it until the 2nd of June. And so she doesn't have access to her funds because she.
What if we make the judgment the 5th, and if she pays it, we can set it aside?
Okay.
I can do that.
Okay. So what I'll do.
However,
Go
Judge,
ahead.
I still have to turn my keys in. Don't want to say
That's
the
fine.
H word, but I'm going into the H word. So I have to turn my keys in regardless, because the facility that I go to on the 2nd. So I'm still going to pay it. I appreciate that, but the keys will be turned in by the 2nd at the latest.
All right. So here's what we'll do.
Okay.
To protect the plaintiff, I'll find there's no tribal issue after hearing. I'll issue a judgment for possession for that total amount of $48,46.31. And then I will indicate that if it's paid or defendant moves, the judgment will be set aside.
Okay. Thank you, Your Honor.
Not a problem. All right. Thank you, Ms. Nichols. And
all right.
All the best to you, okay?
Thank you, guys. Bye now.
Take care. Court does call the case of Gulfside Lakes versus Dewan Winter Mate.
James Singh for the plaintiff. We need to confirm whether his Hawk application is still pending.
Okay.
And so permission to share that.
Yes.
And, so yeah, he's got an open application on it. Alicia over at SLS, they're waiting on documentation.
Yes. Okay. Oh. So here's what I'm doing with those. Since it's still pending, you're gonna get that documentation over to him? Yes. Okay, you need to do that as soon as possible. I'll adjourn it out 1 week to the 30th, 2025 at 3 p.m.
Okay, thank you.
Okay, thank you.
Thank you.
Eric Lofstrom versus Derek Gideon.
James Singh for the plaintiff.
Your name, sir?
Derek Gideons.
Thank you. It's a termination.
Termination, month-to-month tenancy terminated by notice to equipment. Notes I have says that he was here last week and said that, well, actually on the 16th, so 2 weeks ago. No, that's last week. Yeah.
Last week.
And said he was going to move.
Sir?
What I said was I needed some time to move because I just literally got notified on, I think, the first week of May that he wanted the property, and I'd been there several years actually taking care of the property, and I hadn't heard from the owner of the property in over a year. He hadn't said anything, so this kind of just came out of the blue. I'm just asking for 60 days to move out, to try to find a place to move out to. And I mean, I'm a small business owner and this is my busiest season. And so it's a time crunch for me as far as trying to get out. But I have no problem relinquishing the property or anything. I'm not in dispute of that at all. It's just a matter of how much time do I have to get out of there. And that's what I'm asking for, 60 days in order to find another place. I've actually made an offer on a place to purchase, but waiting to hear back from them. I should hear back on Tuesday whether or not they've accepted the offer and then go through closing. So I'm just asking for 60 days to get out.
I don't know, I draw your attention to the notice to quit that was sent by Ms. Gazzari on February 26th. That means that Monday is 90 days since the notice was sent.
I never got the note. I got the summons that was taped to the door of the building, of the house, but I never got any notice. All right. That's why I showed up last Friday on the 16th when I received the summons.
All right. Sir, I have a notice that indicates that one was sent to you on February 26th of 2025. Indicating that you had to leave by April 1st of 2025. That's the first notice.
And once again, I'm indicating that I didn't get the notice. I'm not saying it wasn't sent. I'm saying I didn't get the notice, but I did get the summons that was taped to the door. And I got the summons that was sent in the mail from the Ann Arbor courts and from the Ypsilanti court system.
All right. So 60 days isn't going to happen. If you had to be out, how soon could you be out, sir? Because otherwise, what happens if there's no defense to it. So if I were to grant a judgment today, just to put it all in perspective, if I grant a judgment today, you'd only get 10 days. But I hear what you're saying, but I know I can't get, the 60 days just isn't going to happen.
Like 30 days. I mean, because that's literally, I'm working on projects in Indianapolis, Cleveland, and here in Michigan.
I hear you. I'm just saying, I'm just trying to lay out the parameters of what we, all right, here's what I'll do. Over the objection of plaintiff, I'll grant a judgment for possession with a redemption amount or a redemption date or no redemption amount with a writ to issue June 20th. That's about 30 days out.
Okay.
Okay.
Thank you, Your Honor, and I had my staff email the judgment to Ms. Weidling, and
okay,
I'll change the date on it if she'll be so kind as to print a copy for me.
Okay, we'll get that. Thank you. All right, sir. Thank you. Good luck to you.
Will I be getting something in mail or how?
Well, here's what we'll do. If you want to wait a little bit,
okay,
then they're going to get the judgment into us. Okay, we're printing it. They'll get it to me, get a signature, we'll get your copy.
So June 20th.
It's June 20th.
Okay.
All right, but we'll get your copy from it.
Okay.
The Haven versus David Demara.
James, thanks for the plaintiff.
David Demara? Not here. Thank you. How much is owing? How much is owing?
Case, Your Honor, it's 1447.26 in rent, 1447.26. The costs are 175 for a total of 1622.26.
You're like the default, you may.
Please.
All right, go ahead. I will grant that you had previously been sworn, you gave me the numbers. I'll grant a judgment.
Was I sworn earlier?
Didn't I?
Yes.
Yeah.
Yes, you were.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested. The writ issue. You quickly look happy for, oh, there we go. Court calls the case of Provident Asset Management versus Sandra Moore.
James Fink for the plaintiff.
Sandra Moore? Yes.
One in Zoom at one point in time and then called the clerk's office that she realized it was my person, so she was on her way.
Hold on.
I got that notice at 2:40 that she was coming.
So I'll pass it. I'm gonna give her a chance to show up. And then we'll deal with it. Why is he so, you know? I've said about everything. Actually, Mr. Fink, I was asked by somebody I'm related to. She said she hadn't seen you in a while. She asked how you were doing. I told her you were doing just wonderful. Cranky as usual, but you were doing just wonderful.
Well, Your Honor, I would appreciate it if you would reply to my favorite Simpson with a JD that I appreciate the inquiry and that I'm doing better than I deserve and that God is good to me.
Okay, I will certainly let her know. You know, I don't know how you appear before a judge calls it a second bench, but that's all right. Okay. All right, so then we gotta get set up for the 3 o'clock and we gotta wait for her. I'm gonna step off, they can remain.
You've been there 3 years, right? Has it changed since you were there?
Yes, sir. I didn't realize it was that long.
Yeah, there's 2 houses. Are you on the north or south side of the street? South side of the street. Yeah. There's 2 houses a little bit down the hill. White 2-story house and the one next to it. Those are both moved there from other places. I was gonna say, you think what somebody maybe somebody says. Before you get back. I remember you used to go there like around the pandemic. Yeah. All right. 3-day district court for County of Washington, State of Michigan is now back in session beyond.
Maybe see. Yeah, Provident Asset Management versus Sandra Moore.
James Fink for the plaintiff.
Hello,
Hi,
what's your name?
Sandra Moore.
Okay.
Your Honor, Ms. Moore was not here at 2 o'clock when the case
You know
was
what?
supposed to be called.
I don't even know why you're so.
May I?
Poor Ms. Moore. Ms. Moore said she's been here. Then all of a sudden she realized it was in person and decided she'd come now.
Yeah.
Well,
And I have to give her all the credit in the world. So Ms. Moore, while you weren't here, this is what I'm gonna tell you what happened.
Okay.
I was gonna wait. I was gonna pass your case. Mr. Fink started giving me all kinds of grief. I said, I am gonna wait for Ms. Moore to show up. So I am so glad you were here.
Thank you.
And I was gonna do nothing.
Your Honor, you won't be surprised to know that the half hour that Ms. Moore and I just spent together is probably the most enjoyable 30 minutes I've had in this courtroom in years.
Wow. Wow.
And because she's so delightful, not because of anything else. She has applications pending at Hawk.
Okay, very good. I'll adjourn this out 1 week, Ms. Moore.
Okay.
May 30th, 2025 at 3 p.m.
Okay. 3.
Okay,
Okay.
and I'll look forward to seeing you next week.
All right. See you then.
All right.
Okay.
You're gonna Zoom.
Doesn't matter to me.
Well, we're having a pretty good time, so.
Okay, I'll come back.
I'll wait till you're done. Thank you.
All right, take.
Brushwood Properties versus Craig Mattingly. And Stacy Stovall.
Is Miss Stovall gonna be?
She told me that she's in here right now. She doesn't know if she's in here because it was.
Oh, she's.
I'm right here.
You're right, she's here.
Yes.
David Fanter, on behalf of the plaintiff. Your Honor, we have a condition, we spoke last week about doing a conditional dismissal. I sent it to them. The amount of rent that's owed is total of $4,027.24. They're gonna start paying $750 every 2 weeks, starting June 2nd. The money will be applied first to current rent and then to the balance. I sent a copy of this COD to them yesterday. Mr. Mattingly has signed it. I assume Ms. Stovall, I guess she can speak for herself. Did you see this, Ms. Stovall?
I did, yes.
Okay, do you have a camera by any chance, Ms. Stovall?
I don't. It's working right.
Oh.
I'm at work
Okay.
right now. Yeah.
Oh, okay, gotcha. All right. So you read over this conditional order dismissal, both of you?
Yes, sir.
Do you have any? You read?
Yeah, I just had a question.
Yes.
So it says that we're gonna keep up with the payments every 2 weeks, and I'm fine with that. But my concern is, or I just have a question, if for some crazy reason that we can't make the payment, my concern is that there won't be another hearing. Is it true that we'll be evicted within the 10 days without a court hearing?
That is what this.
Is that the only option that we have available? Like, instead, like, if we can't make the payment for some crazy reason, can we be back in front of you?
Well,
Your Honor, can I make a suggestion?
here's the thing. If you can't make the payment, you should really be contacting either Mr. Fantera or.
Okay. Yeah. Right.
What I was gonna suggest is, what that says is that, if you don't make the payment, I can file an affidavit of non-compliance, and yeah, you'd essentially be evicted pretty quickly. But there's another option, is to make it a 4A case and change, which is basically that if you don't make the payment, I file an affidavit of non-compliance. And Your Honor, I'm willing to do that if we can change the 14 to 7. So if you don't make the payment, I would do an affidavit of non-compliance, and then you would have 7 days from getting that affidavit in the mail to object to it. Basically say, you know, why you missed the payment or whatever.
Okay.
I'm willing to do that. I don't really want to do it with 14 days, but if the court could cross off the 14 and put a 7 and check A, I'm good with that. If you're okay with, that'll give you a little bit more breathing room.
Yeah, yeah, that sounds good.
Okay.
Please.
And you're okay with that, Ms. Stovall?
Yes, sir.
If the court's okay with that also.
That's fine. That's fine. All right, I've changed it to a 4A case. All right, any other questions that you have? Ms. Stovall, any questions?
No.
All right, I'm going to sign this conditional order dismissal. I have to apprise both of you that you have 3 business days to think about this. If you believe that there's some legal reason, some right you didn't assert, some confusion or misunderstanding on your part, you'd have 3 days to file that motion with this court. You understand that? That doesn't mean I grant it, but you have that time. Okay? All right, fantastic. Thank you both.
Thank you.
Thank you. Your Honor, thank you. Have a great weekend.
Same. Arbour Meadows versus Lawrence Bowling. And Susie Bowling.
Good afternoon, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Long time no see. Good seeing you, my friend.
It's good to see you as well. Your Honor, this is a motion to enforce a previously issued order of eviction. You actually have granted this motion once. After you granted it, we did our utmost to try to work out an arrangement with the tenants whereby they would transfer title to the property in exchange for a waiver of their rent arrearage, which continued to accrue. Those negotiations ultimately failed We also then obtained a letter that we have attached to the motion that indicates that this home is not in a condition where it can be removed from the community and placed into a storage lot. The only option at this point, in the absence of receiving title, is to demo the home. We did give notice and an opportunity for hearing to these tenants. They have not responded, nor are they here this afternoon. Their balance is at least 3 times what it was at the time the judgment was entered. And so at this point in time, we stand before you, moving for the order allowing us to demo the home in enforcement of the order of eviction.
The defendants having failed to appear, the motion is granted. I will sign the order.
Thank you, Your Honor.
Augusta Woods versus Paul Reedy.
Your Honor, this is a second hearing.
Yes.
Mr. Reedy is very familiar to me, and I believe to the court as well. We go back a while. There's currently a balance of $560.69. There's cost of $218 for a grand total of $778.69. Any judgment that would be entered would have a writ date of June 2nd, and because of the amount involved, I know the court is going to say no writ without a hearing.
I can pay it on the 3rd.
You can pay it on the 3rd of June?
Again, and for next month also.
All right. Here's what I'll do. Judgment for possession, finding no tribal issue after hearing for that amount of the $778.69. Rather than do where there has to be a hearing, I'm going to extend your writ date to June 6th.
Thank you.
2025. All right. So get it paid by that Friday.
For sure.
All right. How you doing?
Pretty good. Good seeing you. Not really. I mean, you know, but.
All right.
All right. Thanks. Have a good week.
You too.
Want to wait for a copy of the judgment.
Augusta Woods versus Eric Roden.
There to be no response in the courtroom. May I be sworn?
Yes. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor. This is a second hearing based upon a rent arrearage. Tenants apparently have failed to appear. Based on my client's books and records, the current rent to retain is $1336.89. Costs are $218 for a total of $1554.89. The writ date is June 2nd.
And I should also say, Richard Robbins. Richard Robbins, no response. Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ issue. Court does call the case of Augusta Woods versus Tanya Rusnak. Tanya Rusnak, no response. You may proceed.
Your Honor, hearing no response, we would move for the entry of a default judgment for possession on this case as well. Based on my client's books and records, rent to retain is $1,071.89. Costs are $179 for a grand total of $1,250.89. Your Honor, the proposed judgments contains a writ date of June 2nd. I will tell the court that Ms. Rusnak called our office and indicated that she was going to be paid in full by May 30th. Under normal circumstances, I know the court would say no writ without a hearing. If the court wants to treat this case as the Reedy case and extend the writ date to June 6th,
all right,
we would have no objection.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ date June 6th, 2025. No Properties versus Latasha Williams. Hello.
Hi.
What's your name?
Latasha Williams.
All right.
Your Honor, this is a second day hearing date. According to my client's books and records, Ms. Williams's balance is $841. There's $175 in costs for a grand total of $1,016. While the proposed judgment does set forth a writ date of June 2nd, given the amount involved, if the court chooses to extend to June 6th, we would have no objection.
How are you going to get that paid?
I'm trying. I'm just trying to catch up. I've been sick, so I missed a couple of paychecks. So I'm trying to catch up. I know I could pay $600 next week and then try to pay a little bit at a time. You said,
Well, the 6th, so you get paid, what, every 2 weeks?
yeah,
Okay. So on the 30th, that's a paycheck for you next week? And that's where you have 600?
yes.
And you don't have another.
Yeah.
Here's what I'll do. I'll grant a judgment to the plaintiff that finding no tribal issue after a hearing. In this case, I'm gonna do this with the writ date. Defendant to pay $600 by the 30th. Well, I'll just put it by the 2nd, by June 2nd. If paid, defendant shall have until June 13th, 2025 to pay the balance. None of this includes your June rent. You understand that?
Yeah.
Okay, but then you got another check coming in then. I got you. I see where you're heading. All right. If you miss either one of those payments, then a writ can issue. Okay?
Yes, I understand.
That'll work for you?
Yes.
Okay. So Mr. Landlord could do some writing.
Okay.
Micro print, Your Honor.
Oh, we'll do it that way. I've signed off on that.
Okay.
You're all set. All right. Take care. Have a great weekend.
Thank you, Your Honor. I think that covers my cases. May I approach for a moment?
Yes, you may, sir. This is Charles Frierson.
The attorney's in too. I'm not sure if I've heard you.
Oh, there he is. Hamptons of Clover Lane versus Frierson and Brooks.
Good afternoon, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
President Brooks, here. If you'd like to proceed, raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, sir.
Your Honor, we'd seek a default judgment for possession only. The rent to retain, according to the books and records of my client, are $4,185.77. The court costs are $214. The total outstanding balance is $4,399.77. To my knowledge and belief, both defendants are neither serving in the military, minors, or incompetent. And it's to my knowledge and belief that the unit was kept fit for its intended purposes.
All right. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Thank you. Sutton Ridge, 1 versus Tidala Brown.
Attorney Hamdi Sob on behalf of the plaintiff.
Hello. What's your name?
Taylor Brown.
All right. What's plaintiff's claim in this case?
Your Honor, this is a second court hearing. The rent to retain currently is $4,621.18. There are court costs of $175. The total outstanding balance is $4,796.18.
Ma'am, how are you intending on getting?
I'm gonna move. Actually, I'm moving in the process of moving. I lost my job. I was sick for 2 months, so I lost my job. So I don't have a way to pay right now, but I want to be able to pay it off so it won't go.
Okay. So when do you think you'll be moving?
I'm trying to move now, so before the end of the month, I'll be moving.
Before the end of the month, you're trying, okay, here's what I'm gonna do then. I'm gonna throw no tribal issue after a hearing in this case. I'm gonna grant a judgment for possession to the plaintiff in that amount of $4,796.18.
There's a $4,000 that includes June's rent because I don't know.
No.
What does that include? Because that's not.
Just through May.
I don't know why, because I only had skipped May. That's the only month that I didn't pay, so I'm not sure why it's 4,000.
Well, that's what it was the last time we were here. That's the same amount.
I haven't been here before. I would try to do Zoom last week and I wasn't able to
Well,
connect.
somehow or another, or maybe we had a hearing last time. That's the same amount they gave me on that day.
That's not what my paperwork says. My paperwork
Pardon?
is 2,000 and something.
I know, but that would have been for the previous month.
I may. Okay,
So, well, no, I'll explain to you. When they filed their paperwork, they filed it in April.
mm-hmm,
So the $2,540.61 was what you owed through April.
okay,
We're now here in May, so they
added
your
that.
May rent on.
Okay,
Okay?
okay,
All right. So I'm gonna do that in that amount with a writ to issue in 10 days, which will be June 2nd, but you're gonna be out on the 30th.
mhm.
And then what I suggest is regarding this amount is contact them and arrange payment plan to try to get that paid off.
Okay,
Okay?
all right, thank you.
All right, thank you.
Have a
Good luck to you.
Thank you.
Court does call the case of Sycamore Meadows versus Terad LaFleur.
Attorney Hansi Sob on behalf of the plaintiff.
You do, Your Honor?
I'm doing well. Your name?
Terad LaFleur.
All right. And how much is owing on this?
Your Honor, the current balance on this matter is rent to retain and $1,412. Court costs are $175. The total outstanding balance is $1,587.
Getting there.
I'm not sure. I think it's still some discrepancies in the numbers there. I do have a application pending with Hawk, and they're still going back and forth with the ledger and trying to get the numbers right.
So you have an application with Hawk?
And Autumn, we just received the system just got back up with Sycamore Meadows. It's been off about 2 months now, I believe.
Okay.
So they just got the paperwork. They just now
They just
started.
got the paperwork at Hawk, you mean?
Mhm.
Okay.
And they're still waiting on it, getting everything figured out. So I'm not sure what the timeline is on that.
Okay.
Your Honor, we did give the paperwork to Hawk on May 19th.
On May 19th?
Yeah.
Okay. And we have a court liaison, so can you verify, if you don't mind her telling me, that they're still working on it?
Your Honor, yeah, there is an open application, the caseworker that he mentioned. The numbers that she had on the 22nd were significantly higher than what's being stated here, so.
Okay, so the number was higher, it's now lower.
I'm not really sure.
So I don't know what's going on.
That's okay. And I know with Sycamore Meadows, there were some issues. So here's what I'm gonna do. I'm gonna adjourn this out 1 week to May 30th, 2025 at 12 noon.
Well, can we do any later time? Sorry, can we do any later? I'm just trying to go to work.
No, I can't because I try to set it by complex.
I got you.
All right. So I'll set it then. We'll see where they get to with the information that's over.
I was just curious, Your Honor, if the ledger that the attorney is possession of now, could that be shared with our caseworkers? Because there's quite a huge discrepancy.
Got
I
it.
just want to make sure it's discussed properly.
I could tell you exactly who we shared it with, if that helps.
Yes.
We shared it with, give me one. We shared it with a Miss Orda, Autumn Orda.
Okay, that is correct.
Okay. All right.
And
Okay,
that was the numbers that I just gave to the court.
So they should have these numbers.
That's what I'm confused about. Is these numbers the 11587? That's what was shared?
Yes, that ledger with the court costs, that's what we should. So, okay, so we'll figure it out. We'll get it straightened out. All right, take care. Have a good weekend. Sycamore Meadows versus Erica Jimerson.
Attorney Hansi Sob on behalf of the plaintiff.
Hello, Ms. Jimerson. How are you?
I'm good.
All right. What is plaintiff's claim on this today?
The The rent to retain is $2,428. Court costs are $175. The total outstanding balance is $2,603.
600 and, I'm sorry,
$2,603.
$3. Got it. Okay. What do you have to say?
I'm working with Autumn as well. I agree with them.
So you got an application at Hawk?
We're just waiting on Sycamore, and those sound like the right numbers to me.
Okay, now are you starting to, you're gonna
Okay.
yell at, are you gonna yell at me again?
No,
You did it last time.
I love
Are
you.
you gonna yell at me again? There's nothing I can do. No, you came in here.
You're the best person ever. I watch you every day on YouTube. Like, come on.
Okay. Well, thank you for that, I guess. All right, so what I'm gonna do is I'm gonna adjourn this over. Let's see where Hawk is at, the 30th next week, 2025 at 12 noon.
Okay, so can I have a question?
Yes.
Does Autumn have this information? Because I was emailing her today, and she's just wanted the updated ledger.
They do.
They
Okay.
do. That's the ledger they have that was sent over.
To the same person. I just.
Okay.
Okay.
Got it. Okay.
Well, I'll email her when I leave.
Okay.
Thank you.
Have a great.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.